We're live.
Good afternoon. This is the House Judiciary Committee. It's the 17th of February, 2022. We've got a number of bills that we're going to hear today, and we are going to hear most of them with on the 3 and 2 rule, 3 minutes for the sponsor, 2 minutes for everybody else. Two bills are going to be on the 2 and 1 rule. Those are House Bill 859, Delegate Juanita Fisher's bill that was introduced last year, and then 561. Another bill that was heard last year. We've got the first bill on the docket is House Bill 823. I dropped this bill on behalf of the Maryland Judiciary, and they are here to present on this legislation. So we'll go right ahead. We'll treat, if Richard Barton is a judge, I apologize. I'm not sure if he is a judge. I know that it says that Judge Margaret Kent is here. I'll give the 3 minutes to her honor, to Judge Kent, and then go to Richard Barton and Betty Romero. Then we'll take the panel of opponents. So if we can, and I am talking a little bit more because I'm trying to give Judge Kent the ability to get on the line. Judge Kent, there you are. All right. I don't know if I've offended Mr. Barton. We haven't met. You're not a judge, or are you?
No, sir. No,
All
sir.
right. Well, we're going to go and give 3 minutes to the judge. Then we'll give 2 minutes to the rest, and we'll go from there. So Judge Kent, please go ahead.
Hi, thank you so much, Delegate. I am Peggy Kent, and I am Circuit Court Judge here in Worcester County, Maryland. Before I was appointed to the bench, I was the family law magistrate for over 20 years. And as such, I presided over the truancy court, both in Worcester County, actually, and in Somerset County. When it first got established in the First Judicial Circuit by virtue of Delegate Norm Conway's bill. I'm here today to lend my support to House Bill 823, which is a bill that we hope will strengthen the truancy courts throughout the state as a tool in addressing truancy in children. Gray Barton is here because Gray is the program director for problem-solving courts. So he's kind of our go-to, and truancy courts are, in fact, problem-solving courts. They are, by their nature, coercive as opposed to punitive. They're strength-based, geared toward rehabilitating kids. And they are, truancy courts in particular, are geared toward addressing each child's reasons for truancy, and hopefully coming up with ways to re-engage them in school. I am sure you all are aware of the science behind chronic absenteeism. They talk about the school to prison pipeline. The fact is that various reports, including one recently from the Coalition for Juvenile Justice, reports that 82% of all inmates in adult prisons dropped out of high school. Kids who don't finish high school, we know historically, have a high rate of employment-related issues, low-paying jobs, unstable career positions, higher unemployment rates, higher rates of drug use. Honestly, our high school dropouts, according to the science, cost our communities over the course of their lifetime about $800,000 per individual. Think about that. And that is because of increased utilization of our social services, of our justice systems, decreased tax revenue from lower earnings, that type of thing. in my experience, hearing these types of cases, I feel like the academics that the kids are missing out on is huge. But honestly, in my opinion, as important are these other intangible critical skills like learning and working next to somebody who looks different than you. Learning to get along with people that have a different set of values, a different religion, developing tolerance for that and flexibility and understanding, time management skills, right? Which goes hand in hand with self-discipline, learning to abide by someone else's rules.
Your Honor, we're going
Yes.
to need you to begin to wrap up, please.
Okay, I'm sorry. I'm a fan of this bill because it does a couple of things. It strengthens the truancy courts in not requiring courts who want to have a truancy court to appeal to the legislature. Courts can establish them on their own. That's number one. Number two, it takes out the word pilot out of the program. It's been around for 18 years. It's no longer a pilot program. And thirdly, what it does is it sort of establishes much more clear strength-based dispositions for truancy courts. Doesn't criminalize them in any way. That's never been what truancy is about. And it doesn't supplant the role of the Board of Education. They're still the first line of addressing truancy problems.
All right, we thank you very much. I'm sure there will be questions here in a moment, but let me
Sure.
go to Mr. Barton for 2 minutes and then Mr. Romero for 2 minutes, please. Mr. Barton.
Mr. Chairman, I am here just in case there are questions about problem-solving courts or truancy courts, so I could see my time.
All right, that's fine. Let's go to Ms. Romero and hear from her for 2 minutes, and then we'll take questions from the committee.
Yes, hi, my name is Betty Romero, and I'm representing the Commission for Women of Montgomery County. And in our body, we support legislation regarding truancy and specifically House Bill 833. And the reason is that I can't believe, or we can't believe that Maryland, which has been pioneering in many other issues regarding human trafficking, it's lacking in protecting children, specifically at-risk youth women and girls. And instead of protecting them and offering services, we're further victimizing them for conditions that they sometimes don't really know are happening to them. Many do not report being trafficked because they don't know they're being trafficked. So if they steal or push drugs or are out as offering sex, we have to study the conditions. Why are they there? And if we put them in the judicial system and put them in jail, we're further victimizing them and just curtailing their future opportunities for education, employment, housing. They will carry this for the rest of their life. Many of the young girls and that are victims of human trafficking are minorities, and therefore their opportunities are not being supported by the state, and that's why we support House Bill 833, and we ask for your support as well. Thank you very much.
Right. Thank you very much. We'll now take questions for the panel. If anyone has any questions for this panel, I'll be happy to hear from you. Delegate McComas, then Delegate Crutchfield. Delegate McComas, please.
Thank you. This is for the judge or any of the folks that wish to answer. The Office of Public Defender has sent in a letter of opposition, and I'm kind of wondering if they're really aware of what your program does, because they're claiming that just a single court appearance increases the chance that a young person will drop out of school, and that is from a 2006 study. And then they quote another study that basically in Washington State, nearly 6% of all admissions to juvenile detention in 2015 were for truancy, And in Colorado, more than 10% of all truancy filings led to a young person being sent to detention. I don't see where they're getting this, because I think you're going to explore, you know, the family and the needs of the child. In other words, you're kind of going to use a, you know, what's in the best interest of the child from what I gather the program has been all about. So I don't know why they have a problem with this, but you could get an incalcitrant child that needs to kind of know, hey, there's a judge in a black robe that's going to, you know, make you straighten up and fly right. So could you please comment on that?
Yes, thank you, Delegate McComas. I'm surprised by that, because I take note of the fact that none of those statistics are coming out of the state of Maryland. Our truancy courts have historically and will continue to be strength-based. And when I say that, I mean, I have dozens of examples for you on ways that the court, in collaboration with perhaps the Department of Social Services or the mental health or the local health department or the Board of Ed, pupil services workers, where we have been able to put together resources to re-engage children. It is not about delinquency. Truancy is not a delinquent act. It is a civil case with civil citations. The only time it becomes something more criminal in nature is when the Board of Education files a petition against the parent for a failure to send. And if that parent is in fact convicted of a violation of the education article, compulsory attendance, then they may be looking at, you know, some sort of criminal sentence. I think the first conviction is up to 3 days in jail. I don't ever do that. What I want to see is the matter put on the stat docket and the case to be continued in truancy court, but for the parent to understand that legally they have an obligation by law to send these children to school. Usually, Delegate McComas, what I'm going to see in that case are the much younger children, kids that are 7, 8, 9 years old, and the parents like, well, I can't get them to go to school. I say, yes, you can. They're not driving. You can get up, you can get them on the bus. But other than that, I can't imagine where there's any sort of inference that this would be criminally related or related to delinquency. It's not.
Okay, thank you.
Delegate Crutchfield.
Thank you, Mr. Chair, and thank you, Judge Kent, and also Mr. Barton for being here. I just want to make sure I really understand the process. Can you kind of just describe, maybe just walk through an example of how this really works?
Thank you, Delegate Crutchfield. Again, the Board of Educations are really the first line that addresses truancy. Our local Board of Ed here in Worcester County, and I suspect across the state this is true, but we have a really proactive Board of Education. They will initially have pupil services workers investigate as best they can, why are we not seeing this child in school? They make home visits, they write letters, they've provided transportation in countless cases. If there still is no school engagement, then a letter goes out from the Board of Education simply saying, look, we've got this program, and you need to know that if this continues, that the court may become involved. Then, if still nothing happens, they file a petition with the court. And then we hear the case. We determine if, according to the numbers, there have been the right number of unlawful absences. And if so, we admit that child and the family to the truancy court. This is not about whether or not they agree to participate like I do in my drug court. You have to have a written agreement. That's not the case. By the time I see these kids, they have been absent maybe sometimes 20 days in a semester without any sort of lawful excuse. So at that point, we institute, I can give you examples. At child recently whose mother is really struggling with her own substance abuse issues. This child has significant mental health issues and has not been receiving his medication or seeing his therapist for the entire first semester of school. We were able to get into place services where he's transported by the Board of Education from school to his appointments. It's made a huge difference. So it's those types of remedies or dispositions that we're looking toward. Sometimes we keep them in truancy court for 6 months. Sometimes everybody gets it right away, and within a couple of months, we graduate them. Does that answer your question?
Yes, it does. Thank you very much. I
Thank
appreciate
you.
that.
Thank you.
All right. Are there any further questions for this panel? Seeing none, we thank you both very much. We believe that Ms. Romero, who testified a moment ago, may have been testifying on a different bill. But in any case, we do thank you both very much for presenting on this
Thank you,
bill.
Mr.
And
Chair.
there is one person in opposition. The person in opposition is Nicole Hanson Mundell. And if we can bring her in, we will hear from her for 2 minutes. And Nicole Hanson Mundell is not here for this bill, so we're going to move on. That concludes the testimony for House Bill 823. We're going to go to Delegate Brooks's bill next, House Bill 650. The vice chair, the former vice chair, now the chair of Ways and Means, is unable to be with us until 2:30. So we will give her a chance to get here shortly, and then we'll go from there. But let's go to House Bill 650 now. And Delegate Brooks, he is here. Let's also bring in Jim McAllister, James Lanier, and Albert Randall. We'll hear from all of them as part of the first panel. We'll give 3 minutes to Delegate Brooks. Delegate Brooks, please go ahead.
Okay, Chair Clevenger and Vice Chair Moon, I don't see him, okay. And members of the Judiciary Committee, thank you for the opportunity to testify before you on House Bill 650. For the record, I'm Delegate Ben Brooks. I represent the 10th Legislative District in Baltimore County. Yeah. The purpose of this bill is to specify that 25% of the net recovery of a claim for workers' compensation is subject to the execution on a judgment for child support arrearages. Current law does not explicitly state what, if any, indemnity benefits can be attached when a child support order is in place. HB 650 merely offers clarity in an otherwise ambiguous statute in determining which workers' compensation indemnity benefits can be garnished. This clarification is in the interest of the judicial economy and otherwise align workers' compensation recoveries with a personal injury recoveries. For that reason, I am requesting a favorable report, and we do have 2 people who are going to testify on behalf of this bill as well, sir.
Traditionally,
Okay.
economic matters level of brevity in your comments there. So let's hear from. Well, I see Jim McAllister. There you are, Jim McAllister. Let's hear from you for 2 minutes, please.
Certainly, Your Honor. I've been
Not
very
Your
much
Honor. No, really, no.
sorry.
Thank you.
You know, as an attorney, I think you recognize that occasionally you make a slip.
Well, we'll give you committee indulgence and let you start again. 2
All right,
minutes.
certainly. Mr. Chairman, Mr. Vice Chair, members of the committee, I'm a workers' compensation practitioner. I've been very involved in the effort to reform the child support system's ability to garnish workers' compensation. The problem is the statute that Delegate Brooks seeks wisely to amend. If you look at subsection B, it exempts from garnishment disability benefits. So what happens is the child support people file the garnishment and lawyers object, saying these are disability benefits. And so for years now, we've been going back and forth to the Court of Special Appeals and the Circuit Court trying to get a resolution. And most of the cases we work out exactly where Delegate Brooks's bill puts it. It's about 25%. They don't know whether they're going to win on their garnishment. I don't know whether I'm going to win. So we agree to 25%. That's the beauty of this bill, is it takes it out. And the reason this has become an issue is the Workers' Compensation Commission is operating with the child support people under a memorandum of understanding that permits them to mine the data of the Workers' Compensation Commission to determine when people with child support arrearages are getting workers' comp benefits. So that's how the issue arises. We think it's a great bill, and it will be a welcome relief from having to fight these issues with the child support people. And it's good for the children who ultimately will benefit from the child support arrearage payments. Thank you.
James Lanier, please.
Thank you. Good afternoon, Chairman Clippinger and members of the Judiciary Committee. I'm not going to repeat what Mr. McAllister said, but just to follow up a little bit, there's 24 different child support agencies, and that's not even counting all the out-of-state jurisdictions we have to deal with. What Delegate Brooks is trying to do is to simply fix the problem. Ever since the case that came down that's in the fiscal note that was in 2017, now we get these arrearages and you get these calls. Well, do I pay you 25? Do I pay you 50? Do I pay you 65? Or do I get all of it? And then you have these internecine fights with child support agencies when all you really want to do is make sure that the child gets whatever they're entitled to and the client gets whatever they're entitled to. This not only streamlines the process of what it should be and brings it into cohesion with all the other types of 25% rearages or payments that must be made, it also makes it clear to any outside agency, any other out-of-state agency, that it's going to be 25%. That's what Maryland has indicated, and that's what it should be. We very much support it and hope that the committee gives us a favorable finding. Thank you.
Thank you. We'll go now to Burt Randall, please, for 2 minutes.
Good afternoon, Chair Clippinger, Vice Chair Moon, and members of the committee. Thanks for allowing me to appear before you today as well. I'm president of law firm Franklin Prokopic, based in Baltimore, and I practice in the area of workers' compensation defense. Now, candidly, my testimony has evolved somewhat since the submission of my written testimony in support of HB 650 on Tuesday. You know, the intent of House Bill 650 was to clarify the impact of child support arrearages on workers' compensation indemnity entitlements, just as the existing statute does for personal injury recoveries. I echo Mr. McAllister's and Mr. Lanier's comments as it relates to the problems that practitioners face and the uncertainty that the stakeholders, the recipients and beneficiaries face when addressing these issues. And this was really to clarify so that there are not all of these arguments that most often, frankly, don't make it to circuit court or the Court of Special Appeals, because financially and the attorney fees involved, it's not always worth it to pursue it in that way and takes so long. But yesterday afternoon, however, I learned that the Maryland Department of Human Services proposed amendments to the bill which would remove certain entitlements from the bill's language, specifically those for temporary total and temporary partial disabilities and vocational rehabilitation compensation. The department indicated that those entitlements are already subject to limitations under the Federal Consumer Credit Protection Act. As of my testimony today, I don't believe that a position has been offered by the department as to whether it feels that the inclusion of those benefits would be merely duplicative, or if the department's taking the position that including those entitlements might somehow be in contravention or alter existing federal law. Certainly, the intent of the bill is to comply with federal law and clarify existing Maryland law, which omits specific reference to workers' compensation benefits. I think all of this discussion, as again, echoing the comments of Mr. Lanier and Mr. McAllister, as well as the department's proposed amendments, and I understand also that Chesapeake Employers Insurance Company is also submitting an unfavorable request and testimony indicating that there could potentially be some alterations that might make it
Mr. Randall,
workable.
we'll need you to start to wrap up, please.
I understand. I would just wanted that. Thank you, Chair Clippinger. Just that the uncertainty is really emblematic of the need for this bill to clarify existing law. Thank you. And I welcome any questions that you may have.
Delegate Shoemaker to begin.
Thank you, Mr. Chairman. I guess this is for my good friend, Mr. Lanier. Let me ask you, I mean, I've done workers' comp claimants work for about the last 30 years, among a whole bunch of other stuff. When we talk about 25% of comp benefits being subject to attachment for child support obligations, are we talking about TT? Are we talking about permanent partial disability? We're talking about all of it. What are we talking about exactly?
Well, I'm not aware of the changes that Mr. Randall indicated. I've only seen the bill as it currently exists, and it would be for all indemnity benefits. Pardon the alphabet soup, but the delegate will know what I'm talking about. TT, TP, PP, and PTD. It's all of it, and voc rehab. So it would apply to all of it. I can already tell you that there already is, child support already takes part of a temporary total disability check anyway.
Yeah.
So that already happens. The confusion normally comes when you get a permanency check for a client, because then there's the, well, how much do we get? We know we get child support, knows they get something, but it could be anywhere from they claim 100% to 25%. Mr. McAllister must have better luck than I do, because I've had various child support agencies want to go to war over how much they get, and the insurance company's caught in the middle with this money that they don't know who to pay to.
Well, I had a judge in Howard County say they're not entitled to anything because the statute excludes disability benefits under subsection B. So, you know, this is an ongoing fight, and clarity is absolutely necessary.
Sounds like a good bill. Thank you, fellas.
Thank you, Delegate.
Further questions for this panel? Seeing none, we thank you all very much for testifying today. And now we're going to go to those in opposition. Carmine D'Alessandro and Vince McAvoy. Carmine D'Alessandro, if we could have them in. All right, Mr. D'Alessandro, you can go ahead and testify for 2 minutes, please.
Thank you, Mr. Chairman, members of the committee. My name is Carmine D'Alessandro. I am Chief Legal Officer for Chesapeake Employers Insurance Company. We insure about 20% of the Maryland market in workers' comp. I also serve as the president of the Injured Workers Insurance Fund, which is the TPA, the third-party administrator for the state of Maryland Employees Workers' Compensation Program. So in total, we oversee here about 30% of the workers' compensation market. We submitted an opposition testimony. We believe if the bill is going to go forward, there were a couple types of benefits that were left out, namely settlements and stipulations. We pay here, just with Chesapeake, about $60 million a year in workers' compensation settlements. The bill is unclear whether those monies would be subject to any sort of garnishment. We obviously, if the bill is going to go forward, would want them in there because that is a tremendous sum of money that would not be included. The rest of my testimony, my written testimony, is more for informational purposes. Right now, we provide to any Office of Child Support the amount they are requesting, up to 100%. We have never lost in court on that issue, and I provided a chart that would show the monies that would be decreased if this bill were in effect. I've reached out to Delegate Brooks, and I believe we're speaking tomorrow. My first point about settlements and stipulations is the big thrust of the opposition, and I believe if that was included, we probably could work out the rest of the bill. So with that, obviously, I'm available for any questions, and then thank you for allowing me to testify, Mr. Chairman.
And Chairman Clippinger, I would consider that a friendly amendment, so we'll get on that.
We thank you very much for that. We'll hear now from Vince McAvoy, please, for 2 minutes.
Thank you so much, committee. And Benjamin Brooks, I want to let you know I'm against this bill. Can you all hear me all right?
Yes.
Great, thank you. Having worked for child support, the largest one in the state for 2 years, what I saw a lot of times were people losing their driver's license. People were having bank liens. I unfortunately did that sometimes, placing bank liens against people. They would have their money seized on Friday, not be able to get to work on Monday, not be able to see their kids over the weekend. All their money had been snatched. No care, no empathy, no help, except, hey, you can file and maybe in 10 days we'll release the account. When the COVID CARES Act came in, there was one group across the nation, one, who didn't get that money. Child support would snatch that money and put it to any arrearage, whether or not the dad had actually just lost his job through no fault of his own because of these non-essential workers. This bill isn't balanced. The court has recourse to do this. And I'm a little bit disturbed when I hear attorneys say, well, it'll just be easier for us to calculate. You're paid, you can go in there and make your case on every single case that you go into when you're going into child support, family law, courthouses. And so I'm totally against this bill as far as setting this. I don't think there's any empathy whatsoever when we're looking and reading this, that permanent partial disability, permanent total disability. This guy, and again, who does disability happen to? The overwhelming amount of men. Okay, that's why he brought the bill. They lost their ability to work as they had. Maybe they're having to take a demotion. They lost their ability to work at all. And as I look at the horseshoe, with the exception of you, Mr. Brooks, who were in NAM, I don't see anybody that's facing, like I've worked with people who took acid in their eye, people who've lost fingers working. This affects people who don't have a lot of recourse. You can still go after that money. Nobody's saying, but when you go ahead and set aside like this is unconscionable in this type of economy. I urge a strong unfavorable. Thank you so much for your time.
Thank you very much. Are there questions for the panel? Seeing none, we thank you all very much for your testimony today on Delegate Brooks' bill. That concludes the testimony on House Bill 650. We're going to go now to Delegate Valentino Smith to House Bill 764. If I can get the folder to actually not stick to my finger. There we go. And we'll hear from Delegate Valentino Smith for 3 minutes, then Rob Scheer and David Morris. I understand that Andrea Mansfield is unable to be with us from the Chiefs and Sheriffs, but we'll hear from David Morris and Rob Scheer along with the delegate. So please, Delegate Valentino Smith for 3 minutes, please.
Thank you, Mr. Chairman, members of the House Judiciary Committee. So good to see you today. The bill before you today stems from an experience I have. I'm vice chair of the DHS budgets over in appropriations. And DHS is the agency that takes care of some of our most vulnerable and challenging children. And there are times when the state has to take custody of some of these children. They're placed in therapeutic settings. These children do not generally agree with where they're set, and they tend to be a high number of runaways. This bill now is attempting to actually put into statute a very prescribed protocol for what will happen when a child in the state's guardianship goes missing. And it puts into place the specific things that have to be reported. And really, this is essential to help make sure that we avoid escalated outcomes between law enforcement and these missing children, because many of them have suffered trauma, and abuse and neglect is sometimes the least of it. And their interactions with the police can be very risky. And it's critical that as much information be known about the child. And we've included specifics, one of the main things being actually a photograph. Good communication with the police on who they're to get in touch with at the local Department of Social Services to bring the children back. And it really goes a long way towards setting out a protocol. It's not to mean that there isn't already some established internal guidelines. Mr. Chairman and members of the committee, there are, but they're not working as well as they should. And so I am very pleased that DHS and law enforcement came together. I want you to know we've been working together. I commend DHS and law enforcement. We were talking as of yesterday. For the staff on judiciary, we have amendments to the bill since the time it was drafted. It will deal with children in the custody of the state, and it will talk about the immediacy of the need for the report to be submitted. With that, there's no opposition. I dare say that sometimes the easiest bills become the more complicated. I hope that's not the route for this one. And I'd ask for a favorable report. Thank you.
Rob Scheer, please, for 2 minutes.
Thank you, Chairman and members of the committee. I come to you as not a public figure and an international nonprofit owner. I come to you as a dad of 5 kids that I adopted through foster care, and a son for the last 16 months has not been home. He has not been home. He has gone from county after county as a 14-year-old, and today he is still missing because we do not have the right documentation given as each time that he's picked up. And what I ask that you consider this bill and understand that these children, they belong to all of us, and you all were voted to take care of the people. And my son, he's one of the people, and we need your help with this bill. Thank you.
Thank you very much. We'll hear now from Dave Morris. If you're operating your vehicle, we'll ask you to pull over to the side of the roadway before you begin to testify, please. Go ahead.
Yes, good afternoon, Mr. Chairman, and I've pulled over in the Maryland State Police Barracks, so I couldn't be safer. Thank you for the opportunity. Dave Morris, Chief of Staff for the Anne Arundel County Police Department, here speaking on behalf of the Maryland Chiefs and the Maryland Sheriff's Associations in support of House Bill 764. We appreciate Delegate Valentina Smith bringing this bill forward and her willingness to work with us to strengthen this bill and achieve its ultimate goals of safeguarding perhaps our most vulnerable children who are under guardianship. We all know that in investigations of this nature, time is critical, and the more time that passes, the greater the likelihood there is of harm or the inability to locate these missing children. So we support this bill and would ask for a favorable report. Thank you, Mr. Chairman.
All right, are there questions for this panel? Seeing none, we thank you all very much, and that concludes the testimony for House Bill 764. Thank you very much. All right, so I don't believe that we have the vice chair ready as, or the former vice chair, sorry, old habits. The chair of Ways and Means here. So we're going to keep going to Delegate Juanica Fisher and House Bill 589, please. Fisher.
I'm here, Mr. Chair. Can you hear me?
I can, and it's it's you, Tammy Bresnahan, and Gloria Brown Burnett, please, right?
Yes, I believe so, Mr. Chair.
All right, we'll hear from you for 2 minutes, and then Tammy Bresnahan and Gloria Brown Burnett. Great.
Yes, thank you, Mr. Chair. Good afternoon, colleagues. Delegate Juanica Fisher from Prince George's County. I'm very excited to be here with the best committee in the House, reintroducing HB 589, which is an adult protective vulnerable adult registry, a record of abuse, neglect, and work group study. This bill will authorize social services to keep and create and condensify a specific registry for vulnerable adults, and will go into place in this bill, which provide a work group to study the best practices to figure out how to conduct a vulnerable adult registry. There will be an amendment offered from the original language of this bill. The amendment basically cuts out any of the appeal process. It adds a local health department member to the work group makeup, and it also extends the date of the work group giving the report back more than a year from what it was in the original bill. I have met with the Department of the DHS with Human Services, and they are supportive of the bill with the amendment. So I hope that the committee in consideration in subcommittee or in full committee will consider the amendment for this bill. I think we all have vulnerable seniors in our communities. And we've all been contacted about elder abuse, scammers, so many other things. And I think this registry will help protect a very vulnerable population that we all have pledged to protect. My panel has way more expertise and specialized than me, so they'll be great for more specific questions. I just thank the committee for your consideration of this bill again this year. And I think we finally worked on a great compromise to move it forward. So thank you again, and thank you, Mr. Chair.
Thank you. Let's go to Tammy Bresnahan, please, for 2 minutes. I'm sorry, for 1 minute. 1 minute's a reintroduction. 1 minute. No Tammy yet. So let's go to Gloria Brown Burnett for 1 minute, please.
Good afternoon. Thank you, Mr. Chair, for this opportunity. I'm asking for your support of House Bill 589, We submit, currently the state of Maryland has no reporting system to retain names of indicated maltreaters of vulnerable adults, as is the case with Child Protective Services. This has left many vulnerable adults exposed to a population of maltreaters who work in various settings where the vulnerable adult may be considered as prey. It's estimated that only 1 in 14 cases of elderly or vulnerable adult abuse is reported. This means the current environment is conducive to those who prey on these individuals being able to do it repeatedly across the state. A registry would pose consequences. It would also serve as an additional screening tool in assisting community partners such as long-term nursing facilities, in-home aid services, and other agencies who employ these individuals who work with vulnerable adults, seniors, and disabled adults. Between July 2020 and June 2021, Prince George's County Department of Social Services investigated 654 allegations of abuse, neglect, or exploitation, financial exploitation against vulnerable adults. 88 of those investigations were indicated, but not every finding gets prosecuted. In several cases, we've had indicated findings of financial exploitation by the adult children or relatives of the client, and the client will refuse to cooperate with law enforcement when it becomes time to move the case forward. Without an abuse registry, these people are free to seek and become employed with agencies and organizations that serve these citizens across the state. The study of existing registries revealed that the registry reduces access of abusers to vulnerable adults and improves the hiring practices of providers. It's expected that the proposed legislation, along with information gathered by a work group, would offer the best practices in vulnerable adult registries to the citizens of Maryland. And in closing, thank you for your consideration, and I ask the committee for a favorable report.
Delegate Arakan.
Thank you, Mr. Chair. My question is just for the sponsor, I think. I just want to confirm that the names of the victims are definitely shielded and not included in any way. And then my sort of second question is, you may have mentioned this, how many states are already doing this? And yeah, that's my question.
Go ahead. You can go ahead, Delegate. I'm not saying sorry, Delegate. Director Burnett, you can go ahead and then I'll go.
I think it's 26 states already have these registries, or 28 states already have these registries.
And then, thank you, Delegate Arakan. Yes, the victims' names would definitely not be anywhere in the registry or the report. And then my hope, along with I think other human services directors and local directors, like my wonderful director works so hard, the work group would hopefully come out with the best practices and how they want to set it up to have sort of a unified approach. It would be my hope.
Okay, yeah, this is great. What a great bill. Thanks.
Further questions for this panel? All right, seeing we were looking for Tammy Bresnahan, but no luck with that. So that's fine. Noted it for the record, and that completes the testimony on House Bill 589. Thank you all very much. Committee, I'm going to have to step away here for a moment, and I hand it over now to Delegate Moon. Unfortunately, I'm not going to be here for House Bill 561. However, I will watch the testimony afterwards. But Delegate, the Vice Chair will take over the committee right now. Thank you very much.
All right. Thank you, Mr. Chair. House Bill 561, Delegate Fisher. It's a reintroduction, so it's 2 minutes for the sponsor, 1 minute for witnesses, and we do have 18 or so people signed up. So we'll start with Delegate Fisher for 2 minutes, and we've got John Wobensmith, Annie Kenny, Ann Hoyer, Paul Griffin on the first panel. So let's you can start, Delegate Fisher, 2 minutes.
Okay, thank you. Thank you, Chair Clippinger, Vice Chair Moon, and members of the House Judiciary Committee. I'm here with HB 561, which is cases involving child abuse and domestic violence training for judges. I got to take this bill on after our illustrious Vice Chair, Delegate Atterbury, went to go be in some other committee. And I feel very honored to take on the mantle for this bill. I know for everyone on this committee, our children and our most vulnerable children are so important to us. This bill requires the judiciary to create a training program for judges who preside with child custody cases, specifically dealing with child abuse. Sorry, I'm just adjusting my notes. Specifically dealing with child abuse and domestic violence. The purpose of this program is to better examine the results and decisions made by judges in child custody dispute cases in which child abuse and domestic violence are found within these cases. There are many other states that are also going through this issue around child abuse and domestic violence within our cases, and what judges and our judiciary needs to look for. The training program will be required to be reviewed and updated at least once every 2 years. And the judicial training program must include specific topics, such as the process of investigating a report of suspected child abuse or child sexual abuse, along with many other topics. The judiciary would be inclined to combine with child abuse and domestic violence organizations, informing the training for judges who authorize child custody cases. You are going to hear from experts, from parents, from people that have really struggled to find peace and safety for their children and or themselves. And I think that this bill is asking judges to be more just involved and have the tools that they need to really make great decisions. I will tell you that just in my time practicing, no lawyer is an expert in every single topic. There are things that I can speak to in our committee that I experience, and there are things that I learn about every day just sitting here with all of you. And I think that having training on child abuse, thank you so much, Mr. Chair, is so important because not everybody knows it all. And so I will leave it to my panel. Thank you so much, Mr. Chair.
Great. And actually, we're going to do this as a panel of 6, 2 panels of 6. So we had called John Wobensmith, Annie Kenny, Ann Hoyer, Paul Griffin, Tara McLeod, and Stephanie Hammer, and we'll take them in that order, starting with the Secretary of State for 1 minute.
Vice Chair Moon, good afternoon, members of the Judiciary. I'm John Wobensmith here as chair of the work group that studied child custody proceedings. In addition to my written testimony, I'd like to add that you all saw the wonderful display of the founding documents of our country recently in the State House. Reading again the Declaration of Independence caused me to ask some questions. First, aren't Maryland children entitled to life, liberty, and the pursuit of happiness? And second, aren't Maryland children entitled as citizens not to be placed in a situation by their government where they're raped, sexually molested, abused, or even killed, like 15-month-old Prince McLeod, murdered by his father during an unsupervised court-oriented visitation? How many more at-risk children have to be killed, raped, or molested before action is taken? Some say this is an unnecessary bill as it's already being taught to the judges. The work group heard from so many voices a clear message. It's not working. Life, liberty, and the pursuit of happiness is what our founders expected us to enjoy and the new government to keep. Please help these vulnerable children.
Thank you very much. Next, we'll hear from Annie Kenny for 1 minute.
Hi, my name is Annie Kenny, and I am a single mother to 3 daughters from St. Mary's County. Several years ago, I discovered that my now ex-husband was abusing our oldest daughter. He was indicted on felony child sex abuse charges and is now a Tier 3 registered sex offender for life. It took 7 months in criminal court for my children's father to be convicted, but it took 4 years in family court for me to get a no contact order in place protecting my children from him. It's important to understand that the father of my children was already convicted and already a registered sex offender before I ever stepped foot in family court. He was granted supervised visitation, weekends at his mother's house, and a year into his supervised visitation, it became known that he was repeatedly sleeping alone with our 2 daughters. I stopped sending my girls for their visits and found myself in court for months fighting contempt charges. But the magistrate in our court case still did not revoke my ex-husband's visitation and even directed me to start including him in my daughter's mental health treatment. I continued to refuse, and my non-compliance just kept escalating my ex-husband's anger. I've spent tens of thousands of dollars on legal fees and lost years of my life fighting against an already proven to be dangerous man just to keep my children safe. And the only reason I am not still in active family court is because he is currently incarcerated, accused of molesting multiple children and having pled guilty to molesting a 10-year-old girl. The day he was arrested for these new molestation charges, I still had an active court order telling me to send my daughters to his mother's house for visitation every other weekend. I just was refusing to do it. Our magistrate used to end every case hearing for all of the cases in the courtroom.
Sorry, you're going to have to wrap up.
Thank you. By saying, in this courtroom, we don't divorce families, we divorce couples. And while I think it's a beautiful sentiment and I admire his commitment to maintaining relationships, some families need to be divorced. Some families need walls to be built to keep the children safe. Thank you for your time.
Thank you very much. Next, we'll hear from Ann Hoyer for 1 minute.
Sorry, I was muted. Good afternoon, Vice Chair Moon. I'm Ann Hoyer. In 2018, I was honored to be appointed to the Legislative Work Group. SB 561 is a product from that work group. This group was charged with seeking out common sense solutions to address the challenges that family courts with when overseeing custody cases where allegations of abuse or domestic violence is alleged. As anyone can imagine, these cases are far from easy and very complex. One of the recommendations was to provide a life-saving training/awareness to judges presiding over these very difficult cases. This will give them the necessary tools to assist them in making life-altering decisions for children and families, as well as alleviate some of the anxiety and apprehension typically associated with judges participating in family court matters. It may also protect them from a life of PTSD in the event of the decision going bad. That being said, they need to be aware of the current scientific-based tools that are available to them. These training subject matters can be the difference between a life of abuse or, in some cases, death. Resolution 72 was passed in the U.S. House of Representatives recommending that all states put child safety as the #1 priority in custody and parenting decisions. I want to thank you for allowing me to speak today, and I'm urging a favorable vote on HB 561. Thank you so much.
Thank you very much. Next, we'll hear from Paul Griffin for 1 minute.
Thank you, Mr. Chairman. My name is Paul Griffin. I'm the legal director of Child Justice. I also was on the work group with the other folks you heard from. I do these cases for a living every day in custody courts, so I've seen firsthand where things are. I've been asked to comment on the judiciary's concerns about the separation of powers. We've read the letter from the judiciary, and frankly, we don't find it very compelling. Our view is, I think it's accepted wisdom that the judiciary does not completely control the courts by itself unilaterally. It's partnership with this body and the administration at some level. We just heard testimony earlier from Judge Kent where she's asking for help from this body setting up the truancy courts. That's a perfect example of where these bodies work together. I would direct your attention to Article 4, Section 18 of the Maryland Constitution, where it says, quote, "The Court of Appeals from time to time shall adopt rules and regulations concerning the practice of proceedings in the courts, which shall have the force of law until rescinded, changed, or modified by the Court of Appeals or otherwise by law." Now, the courts have interpreted the otherwise by law to mean that the Maryland legislature can make changes to the rules and the procedures of the courts. I direct your attention to Johnson versus Swan, which is 314 Maryland 289, and a recent case we also had in 2020, where the court again recognized this body has the power to make regulations and rules for the courts of Maryland. I do not believe. Okay. I would also point to the Senate cases under 3806 CJP, where this body has put forth what it wants in its Senate courts. And finally, I'm holding up here this law book. It's the family law book. This is 700-page book where this body has made laws for the for the judiciary to carry out when hearing custody in other cases. We don't think that there truly is a separation of powers issues here. And finally, just let me say, for more details on this, please review the letter submitted, the testimony submitted by the National Family Violence Law Center, which gets into much further depth on the separation of powers. Thank you.
All right, thank you very much. Next, we'll hear from Hera McLeod for 1 minute.
Thanks so much. My name is Hera McLeod. 9 years ago, my 15-month-old son, Prince McLeod, was drowned on the 4th unsupervised visit with his father. Many who hear about my custody case are quick to dismiss this as an extreme example, but I assure you that in the 9 years that I've been studying and advocating for family court reform, I've seen a very common thread running through cases, particularly those where children are in danger. Judges don't have the required training to properly assess cases that involve elements of domestic violence and child abuse. And if my words aren't compelling enough, let's take a quick look at the Montgomery County judge and what he said to us in our court case. I'm in family law because I have to be. It's a required 18-month rotation. I don't like it, and if I could choose not to do it, I would not do it. And it's for these kinds of cases. Let me tell you what I conclude this case is not about. It's a lot of smoke. It's a lot of smoke. Well, there's a lot of smoke. The difficulty is with all the smoke, I can't see clearly. I don't have the answers. I don't have any superior knowledge beyond anyone else. What I do know is I'm going to make a decision based upon the law, based upon the testimony that I've heard, and based upon what I think, right or wrong, is in the best interest of the child. Unfortunately for my son, what this judge thought, because he didn't have access to the superior knowledge he referenced, which this bill addresses, wasn't in the best interest of my son. He sentenced my son to death because of his assumptions, bias, and a lack of knowledge of how to properly assess a case that involved domestic violence and child abuse. This same judge told me that my son's case needed to, in order to reach the threshold of a child in need of action, a CINA case, he'd have to come home with cigarette burns on his back. My son came home to me in a body bag. I'm asking you all to take a step that those before you were unwilling to take to protect the children who will come next. This bill doesn't fix everything that's wrong with family court or our justice system, but it's a necessary step that would give our judges the tools required to make the right decision, the decision that would save the children who would come next. Thank you.
Thank you very much. Next, we will hear from Stephanie Hemmer for 1 minute.
Can you see me? Okay, great. My name is Stephanie Hemmer, and I'm testifying to express my strong support for HB 561. I thought I would share a story of a patient which sheds light on the trauma caused by sexual abuse. My patient's father had sexually abused him from the age of 3 to the age of 15. He subsequently developed bipolar disorder. This mental illness is characterized by extreme mood swings. Victims of the illness often have poor impulse control. This can lead to social, legal, family, and physical health problems. Drug use, sexual promiscuity, and illegal activity often characterize a life filled with tragedy. Furthermore, this patient demonstrated self-harming behaviors. For example, he cut his wrist on the railings on the wall of the unit. He would run from staff to the railing and cut himself as blood flew from his wrists. He would scream and cry inconsolably. The behaviors always returned after we gave him medication. Trauma cannot be cured. Patients who have been abused do not fare well as adults unless they receive support, therapy, and sometimes medications as children. It is safe to say children who are abused who remain in close contact with the abuser are overwhelmingly doomed to a tragic outcome. Lives are ruined forever. Again, I urge the committee to vote in support of this bill. The mental health of abused children is at grave risk when allowed to remain in contact with the abuser. We owe it to all children to do what we can to protect them and their future well-being. As I close, let us remember the words of Frederick Douglass. It is easier to build strong children than to repair broken men. And by the way, I don't know if I said I was a psychiatric nurse, but I was one for 15 years. So those are my credentials. Thank you.
All right. Are there any questions? And can the witnesses all mute? Thank you. All right, we got one from Delegate Cardin. Go ahead.
Thank you, Mr. Chair. And thank you, Delegate Fisher, for this very compelling bill.
The state board, the Maryland State Bar Association wrote a letter that said that unless you adopt certain amendments, that they would be unfavorable towards it. The family law and juvenile section of the bar. Have you looked at that? Have you talked with them? Is there anybody that you want to let speak about whether those amendments are reasonable?
I did look at them, but I'm gonna let Ms. Hoyer take that question. I think she'll give you a better answer than I can give you, Delegate Cardin.
I'm actually going to bat it over to our lawyer, Mr. Paul Griffin.
Okay, thank you.
Thank you.
Thank you. I haven't seen this one, but I've seen the letters that they've sent before, and basically the amendments are gutting the bill, to be perfectly honest. So folks who say they support it with amendments really are trying to eliminate all the training that we're trying to have here. One of the things that they say is that we're too detailed and what we're asking for in the training, and things change. But really what we're asking for is child development and some other areas. These titles don't change. Some of the science within them changes. And the bill specifically requires us to update, or requires an update of what the training will be every 2 years. So while the notion of child development doesn't change, again, the specifics within it change, it will be updated as the science and our understanding of things change. I can honestly say that the purpose, the judiciary believes that they're giving sufficient training to the judges. They've made that patently clear. We vehemently disagree. I can tell you story after story, if I had all day, anecdotes about judges who clearly did not have the first understanding of some of these topics. If we go with the amendments as requested, we're basically saying to the judiciary, you go ahead and create the training as you think best. And that has proven not to work so far. We just don't think that that is the way to go. We think that these have to be drawn out and presented to the judiciary. Otherwise, they will not, in our view, adopt the training that's necessary. I also add, we asked the judiciary to come join us on this committee. They refused. They declined. We asked them to come testify before the work group. They declined. We really want.
I was referring to the State Bar Association, not the judiciary.
Okay, I understand. But I mean, my view is they're trying to punt this back to the judiciary to allow the judiciary to choose the topics. And I don't think that that is the best course for this body to take. I hope that answers your question, Delegate Cardin. Thank you.
All right, we've got Delegate Bartlett and then McComas with specific questions.
My question is for Mr. Griffith. I lost you on my screen, but I know you're there.
Yes, ma'am.
I wanted to ask about, we have testimony from the Mid-Atlantic Panda Coalition, and I don't think they're going to have oral testimony. It looks like they just have written. And I found it very interesting about a group that are a bunch of dentists who had to create a coalition that's called Prevent Abuse and Neglect Through Dental Awareness. I mean, that's just how interesting and how far reaching the topic of child abuse goes. And I wanted to see if you may or may not be aware of it. So it might have been a question, perhaps I should have directed to the bill sponsor, and I apologize for that. So no, I'm going to direct it to the bill sponsor. I would love to see that. I'm going to direct it to the bill sponsor. So, so Delegate Fisher, I wanted to see if you could speak a little bit to the Mid-Atlantic Panda Coalition and the fact that a group of dentists are testifying in support of this bill through written testimony. How are dentists and hygienists a part of this, their interest in this bill? Can you explain to me just how far reaching this goes and why this group is a part of this bill?
Yes, I can give you my perspective, Delegate Bartlett, and then I'll also see if any of my other panelists want to chime in. You know, I think what I know in my experience of child abuse and working on this bill with, you know, all of my brave advocates and experts is that abuse can show up in so many ways, and especially in the dental industry, whether it's broken teeth or other, you know, things that are happening to children, they're seeing it in the chair and, you know, feeling constrained as the medical community to do something, especially when that abuse is coming from a parent or family member. So I think it really shows how the neglect and abuse can go in so many different avenues in our community. And I think people obviously have the heart and care about the children and the people that they serve. And so I thank you for bringing that up to the greater committee. And I want to really thank the courage of Mrs. Kenny and other of my panelists that are, expressing the things that they've gone through in order to find solace and help in this bill. And again, the one thing I'll also point out on that, Delegate Bartlett, is that a training doesn't mean we're dictating the outcome in the case. And I think that really gets lost in the bill. And I think, I think that even something as far, and maybe, far people might think of far reaching, like a dental community, also sees the value in that. And I'm not sure if Ms. Hoyer or anyone else wants to add, but that's what I would say.
Thank you. That's very helpful.
All right, Delegate McComas with a specific question.
Yes, sir. Okay, I love being whatever. Anyway,
it's for everybody.
Okay, never mind. Anyway, I noticed that the Bar Association section is concerned about parental alienation syndrome, and that is a kind of there. Depending on who you speak to, it's controversial, one side or the other. And I did have a chance to attend Mr. Eddy's or Dr. Eddy's seminar out in Harford County. And, it's a cottage industry for him. I mean, he does a lot of work on it. So I guess what I'm saying is I think, as long as the curriculum is balanced, because you're never 100% going to know what it is, whether one parent's saying bad things about the other or what, or there is actual abuse or neglect. So I would like to ask the panel to give me their thoughts on this.
Yeah, I will. Oh, go ahead.
Complaint. That seems to be one of their major complaints. They spend a lot.
I'll just say something really short on that, Delegate McComas, and then I think Ann looks like she wants to go, or maybe Mr. Griffin wants to go on that. This is the one thing I will be, you all know me. I'm a straight shooter. I thought a lot about taking on this bill. And the more and more when I sat and I looked at the language and met with opponents, met with folks that are for the bill in transitioning it, I had to really reflect on, no one is using mind control. It's called training. And from CLEs I've done myself, from different experiences I've done, law enforcement training, everything I do in my own professional experience, I can just say, just speaking as Delegate Fisher, it doesn't mean someone took over my brain and made me decide a certain way in a case. And on my decisions and what I think in my legal training. And so again, I would just say to those concerns that it's training, and we're looking at a real intentional harmful abuse of children. And so I do see that. I think there are other bills in this committee, whether it's been child support issues and things like that I've supported. I don't want to see parental alienation. I think I've been really fair on that topic in this body. But I think that having the tools to see something that you can't always see, abuse comes in so many ways. It's not always a broken arm, or something like that, is so important. And that's what got me where I am today in sponsoring this legislation, Delegate McComas. And I think that the opposition, needs to look at that. I cannot imagine that the hours of training this bill's requesting is taking away your 3 years of law school, your bar exam, and the years or decades you spent on the bench. You cannot tell me that. And I don't agree with that. And I will let Mrs. Hoyer give her input on that.
Thanks, Delegate. What I was going to ask you is, I know we were doing the amendments. So PAS language is not included, Delegate McComas, in this bill. So PAS should not be a controversial piece because it's no longer in this bill.
All right, Delegate Davis.
Thank you, Mr. Chair. I recall this bill from last year,
And you guys hold your hats because I tend to deal with, I tend to agree with Delegate McComas. I remember that there was specific language outlining what was supposed to be taught. So, I mean, is there any room to just say training by experts or social scientists, or is there room for that in the bill instead of just training on how to detect one side? That's my question.
So Delegate Davis, so we had the work group that lasted for a year. We had about 14 meetings. And these were experts who were identifying the things that needed to be taught on or made aware to the judges that are currently happening. So because we know the history of the family courts and the decisions were not, a lot of the decisions were not good decisions, the experts did identify, well, they can't make these decisions based upon the education that they are currently being taught upon. So we're closing the gaps, closing the loopholes. We're not saying education that they're doing now or trainings that they're doing now aren't relevant. What we're saying is you're missing these pieces. And these are very fundamental things that we have included in this bill. They're fundamental. It's for, studying the brain development of a child, knowing limitations of CPS, knowing limitations of your police officers, right? Who sometimes don't make the right choices. They're not qualified to say that this is a safe environment, right? A police officer cannot say to a judge, they're not qualified to say that this is okay on a supervised visitation if they're overseeing that supervised visitation. They're not qualified to know whether this child is safe or not. So we need to let the judges be aware of this, that they are not qualified. They're not trained on that. That's just the point. It's an awareness training. It's 20 hours. We passed a bill in the Senate last session for 80 hours to train ball catchers. So I think 20 hours is really kind of a minuscule little step in the right direction.
If I may, Mr. Chair, does the bill require that the information you outline supplement the training that they already have?
You look like you're getting ready to say something.
It doesn't, I don't know that it requires, but in effect, I believe it would. I mean, that would be up to the chief of the Court of Appeals. And we point out that they have their own education section there, but even in their own charter, it says, give me one moment, that the Judicial College will serve as the, quote, primary entity, end quote, for judicial education. So it even contemplates it would have outside training. So whether the chief judge believes, I mean, I'm sure they're going to have their own training writ large on being a judge, but whether the chief judge wants to add extra training in specific things with domestic violence, that would be up to him or her. I don't believe it requires it to be in addition or in lieu of, but it could be either. And I would, if I could, circling back one of the things that Ms. Hoyer was saying, the reason why she brought up the police officer and giving an opinion, that was what led to the unfortunate death of Prince Raines, where police officer testified at the supervised visitation. Yeah, dad looks great. I don't think he's dangerous, which this person was not qualified to render that opinion. And it was in a supervised visitation setting, which any judge should have known from the literature that people act their best at these supervised trainings, at the supervised visits. And that should not be a basis to believe that there's no longer a danger. That's covered in the literature. And I can tell you again, anecdotally, we go through so many, we have judges say so many things in these things that show they haven't learned basic 101 domestic violence or child abuse 101, that we think that they're just not getting to the Judicial College.
Mr. Chair, I wanted to see if one of my panelists, Mrs. McLeod, can also add her 2 cents on that question.
Yeah, I just wanted to clarify. We actually had a police officer testify, and she said that he was dangerous. The judge in my case made the determination that since he hadn't been convicted of all the crimes that she came in to testify that he was under investigation for, that somehow this meant that he was safe enough to be around my son. I think that one thing that is lost a lot of times is when a lot of people hear domestic violence and child abuse, I think we all, tend to make the assumption that it's a man that's committing the abuse. And so while many of us are women that are testifying today on this panel, I can tell you that in the past decade that I've been studying this issue, I've actually worked with a lot of men who were concerned about the safety of their children. One man in particular was actually telling me that his children were made to breathe into the breathalyzer in the car because his ex was drinking and driving. And he was terrified that his kids were going to die in a car accident. And so just because it says domestic violence and child abuse, like we shouldn't make the assumption that men are always the offending people. It actually happens a lot where it is an unsafe mother and the father is trying to protect his children from somebody who is unsafe on the other end.
All right, thank you very much. We're gonna move on to the next panel. We have another 6 folks on the favorable side here: Catherine Spearman, Camille Cooper, Claudia Remington, Linda Singh, Jen Shaw, and Danielle Pollock. We can start bringing them in, and if everyone else who just finished could exit, that would be awesome. All right, so I do see Catherine Spearman is in. You can begin for 1 minute whenever you're ready.
Thank you for the opportunity to testify. In 2015, my 4-year-old told me his biological father, my then husband, had been playing a game with him called Poisonous Snake. He graphically acted out the abuse he had endured. My son explicitly disclosed the abuse he experienced to 2 other adults, including a therapist at a nationally accredited child advocacy center. A custody evaluator was appointed in my case. Her name was Dr. Gina Santoro, and she was asked under oath about her qualifications. Did you take any course only focused on any type of sexual or domestic violence? No. Did you ever evaluate a child to see if he or she was a victim of any type of abuse? No. Have you ever been qualified as an expert in any type of child abuse? No. Have you ever been qualified as an expert in domestic violence? Dr. Santoro answered no. Judge Michael DePietro, the presiding judge for my case and the now chief judge of Baltimore City Family Court, said in his oral ruling, I know there was testimony suggesting Dr. Santoro did not have the requisite knowledge, training, and skills to perform this evaluation, given the nature of the allegations. And I disagree. I do find her testimony credible and afford it great weight. To even get the issue of child sexual abuse adjudicated cost me over $700,000, borrowed mostly from family and friends because I was a stay-at-home mom with no income of my own. It was not enough. I lost legal custody of my children. I lost 50% physical custody to the man my child had told 3 adults had abused him. I filed Chapter 7 bankruptcy due to extraordinary legal fees. I lost my home. My wages are still garnished by Renee Aids, the best interest attorney who represented my children for just over a year and who charged fees of over $360,000, an amount Judge DePietro ruled on and allowed. But sadly, my story is not unique. It reflects the institutional betrayal and harm children and protective parents experience from the very people we turn to for help and protection. Legislation is needed to ensure that judges do have the requisite knowledge, training, and skills. Thank you for your time.
Thank you very much. Next, we'll hear from Camille Cooper. All right, Cooper's not here. Claudia Remington for 1 minute.
Vice Chair Moon and distinguished members of the committee, my name is Claudia Remington. I'm the Executive Director of the State Council on Child Abuse and Neglect, an advisory body to the Governor and General Assembly. We strongly support HB 561. 2 quick points. The subject matters enumerated in HB 561 are a 101 course in these cases. They were carefully drafted by the work group and legislative staff to allow the training to develop as the science develops. The terms used have been used in child abuse and domestic violence research for decades. This language could have been drafted 15 years ago without an ensuing need to amend the statute. Every judge making these altering decisions in the best interest of the child should have this foundational knowledge to ensure sound decision-making. Expert testimony is cost prohibitive, especially for pro se litigants. Whether a judge has this foundational knowledge to determine best interests of the child should not depend on the ability of the child's parents to hire expert witnesses. The amendment suggested by some proponents, deleting everything after page 2, line 2, effectively cuts the bill and leaves us with what we have today. Elective training covering piecemeal subject matters created and implemented by a court system that given multiple opportunities to join, participate, testify, and provide evidence to inform and be informed by legislatively mandated work group failed to do so. For these reasons, we respectfully ask you to be a voice for children involved in these cases and issue a favorable report on HB 561. Thank you.
All right, thank you. Next, we'll hear from Linda Singh for 1 minute.
Good afternoon, Mr. Chairman and committee members. I am Dr. Linda Singh, retired Major General of the Maryland National Guard, to speak on behalf of my support for House Bill 561. And, you know, the challenge that I see with this is while my situation is dated, nonetheless, it is still important and it's still very real for what we're hearing from the situations today. So growing up in my household, one of my oldest sisters was actually removed from our household via the court system because she was sexually molested. What the judge asked me in front of the abusers, essentially, was, did I feel like it was safe to return home? So the first question should have been, can I remove the child from the courtroom to have a private conversation to ask, do you feel like you are going to be safe going back home? Going back home, I was then subject to physical abuse, subject to verbal abuse, and then years later was molested in my household and was put out of my home and found myself living homeless on the streets because I was afraid to tell anyone at the age of 15 years and 9 months. That changed my life. Now, nonetheless, I've been able to overcome that. The challenges that I suffered for a very long time in trying to deal with the anxiety, trying to deal with the emotional stress that put me through, and to be able to create healthy relationships. The good thing is I had a huge support system that I was able to bring around me when I became an adult. But unfortunately, as a child, I did not have that. And so what I would say to you all is, as you think about this has been going on for a long time. Our children deserve more. They deserve more for us. And I don't think that it's too much to ask 20 hours of training for what turns into maybe a lifetime of scars. And so I think 20 hours is sufficient. I think it's adequate, and I think it's good enough. So I ask your support for this House bill. Thank you.
Thank you. Next, we'll hear from Jen Shaw for 1 minute.
Thank you. Thanks for the opportunity to share. I'm going to share a child-centered perspective on this bill. So my experience is with children in recovery after abuse, including sexual abuse in early childhood. I work with assessment and treatment of children. What I want this group to know is that we can't begin our work when a child's right to safety is considered secondary to an adult's right to parent or deemed debatable as we wait for a final decision. This is a science-informed step towards ensuring all invested in the rehabilitation of injured children become confident that recovery does not depend on whether the judge assigned has been trained enough. We ask you to consider child abuse often occurs within the home or by a trusted caregiver. In fact, over 90% of child abusers are known to the child. When one parent seeks safety for their child and the abuser is the other parent, the protective parent will do what any of us would do. You seek protection from harm, not every other weekend or most days of the week, or except for a supervised visit once a week. In these cases, the issue is not custody. It is about the right of a child citizen to be believed when they show or share abuse, and the right to be in a safe environment once they do. A trauma-informed decision in these cases should be the most basic requirement. That cannot happen if training may or may not have occurred. It's common in my field to hear parents and attorneys predict the outcome of a custody hearing based on which judge will hear the case. Some are excellent and well-versed. about the impact of abuse, and we breathe a sigh of relief. The goal today is no longer to have to hope the assigned judge is trauma informed. This bill is one way to show children we mean it when we teach them to just tell a safe adult if they need help, to show them they do have a right to be protected from intentional harm. We all know that children are resilient, but we can't rely on capacity for resilience as justification for a passive response to an active threat to that very capacity. So on behalf of children waiting for safety so they can resume their childhood, please consider a favorable vote today.
All right, and last on this panel, we've got Danielle Pollock for 1 minute.
Good afternoon, Vice Chair Moon and esteemed members. Thank you for the opportunity to provide testimony on HB 561 today. Thank you, Delegate Fisher. And I also want to say thank you to the many survivors for sharing your difficult stories and your wisdom today. My name is Danielle Pollock. I'm the policy manager for the National Family Violence Law Center at GW Law, and we specialize in these matters. We strongly support this bill, HB 561. It's critically important that family court judges are given the necessary tools to accurately assess abuse in these families so that children aren't harmed. This training would help accomplish that, and it can be delivered online. It need not be in person in order to be mindful of judges' precious time. On the separation of powers question, we at the center have done a very close analysis on whether the measures in this bill would meet constitutional muster under Maryland law. We have found that they would, and you can find that analysis in detail in your written testimony from us, which has been submitted to the committee as the litigator Griffin referenced earlier in his testimony. Several states have already passed legislation which requires judiciary to develop and implement such judicial and court personnel trainings, including California, Connecticut, New Hampshire, Washington, D.C., Texas, and Colorado. And furthermore, federal dollars may become available to implement such training in Maryland in a pending provision in the Violence Against Women Act, which passed the House last year and is in the negotiated bipartisan draft from the Senate that was announced last week. So if you have questions about that, I'm happy to answer that in more detail. And also please have a look at our written testimony for more detail on everything I've referenced today. We strongly urge a favorable vote on this provision.
Mr. Chair, are you back?
I am back. Thank you very much. And we'll
the chair of Ways and Means is also here for her earlier bill.
All right, that's fine. So we'll get through this one and we'll move to that one as quickly as we can. Delegate Arikan with a question here.
Thanks, Mr. Chair. Thanks everyone for being here on this really important bill. Could Ms. Remington maybe go into a little bit more detail and talk about the specificity questions? I think we need to expand on that so we sort of know what's actually in the bill and why we don't think that it's going to be a problem for the separation of powers issue.
So the different subject matters that are included are multiple areas of child abuse and domestic violence research. So adverse childhood experiences, trauma, complex trauma, coercive control, delayed disclosure. These are all terminology that has been used for quite ever since I've been involved with the State Council, which has been since 2006, and many of these things many years before that. I've footnoted many of them in our testimony. I can give footnotes for the others if people are interested. There are also processes that happen within the child welfare system that really judges need to have a thorough understanding of what an indicated or an unsubstantiated or ruled out or screened out case means. And those are all really important things that they don't necessarily know. So the list was really carefully crafted. I'm not sure if there were specific questions about specific pieces of the different enumerated subject matters, but I could go into further on that. I really didn't talk about the separation of powers issue, but this is 101 training. There are, I know there have been times when the legislature has asked the administration to become trauma informed. We passed bills last year doing all of that, which really requires training of all the administration, the secretaries, everybody, and to have the courts understand these basic premises for them to be able to make decisions based on the standard in the best interest of the child. They cannot understand that without understanding these basic subject matter areas. Thank you.
Yeah, thank you. Thank you very much.
Further questions for the panel? Seeing none, we thank you all very much. We're going to continue to our next panel. And that is Michelle Smith, Dorothy Lenig, Lori Ruth, Melanie Shapiro, and Maria Netznutska VMR. Michelle Smith, please, for 2 minutes.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. I have been listening to the testimony, so I would like to give just a few remarks and then address questions that have been posed with regard to the Maryland State Bar Association Family Juvenile Law Section Committee, our written testimony. I am Michelle Smith, as Mr. Chair has pointed out, and I am testifying on behalf of the Maryland State Bar Association Family and Juvenile Law Section. We support the initiative for training for judges in these very difficult cases involving child abuse and domestic violence. Of course, we support that. And we support protecting the vulnerable children about which some of the panelists that have gone before me have testified, of course. Our issue is with very granular detail in this particular bill. And I am pleased to hear that there have been amendments made. I am not aware of these amendments and I have not been able to discuss them with our section. So I am happy to work with Delegate Fisher and anyone else that would like to send me the amendments, and I will get them to our section and we will get back with a more substantive review. But there are details in the bill that are more than just 101 training. They give a particular judgment, or they use terminology that is somewhat in conflict in the scientific fields. And I heard Mr. Griffin say that the science within the training changes. And that's why there's language to update it every 2 years. And all we're suggesting is that we don't have such specific language that we have to reintroduce a bill every 2 years to straighten it up. We are asking that the language be much more generalized and that the trainers, the experts in the field, make decisions about the detail that they want to train on. And therefore, we are right now opposing the version that I have understood to be of House Bill 561 unless amended. Happy to look at the new version. Thank you very much.
Thank you very much. We'll hear now from Dorothy Lenig, please.
Good afternoon, Mr. Chairman, members of the committee. My name is Dorothy Lenig. I'm the director of the legal clinic at the House of Ruth. My colleague, Ms. Smith, said it unbelievably well, and I really agree with everything that she said. Everybody supports the idea of training judges. It's not that. In fact, those of you who know me know that I've been working at the House of Ruth for a very long time, and I've been training judges on all these topics for a very long time, as recently as this past October. And the thing that I've most learned is that you want to be flexible on the topics. You want to be able to train on new developments and new research. When I started at the House of Ruth, I was told everybody believed that, let's say, dad could be abusive to mom, but it had no impact on the kids. And what we've learned through the years is that kids living in households with domestic violence, the traumatic impact is exactly the same, whether they're abused or not abused. So that research had to be updated. I really want to build on what Delegate Davis was saying. You have to be able to update the research. You have to be able to be current. somebody on the last panel testified, all these topics have been around forever. Well, they haven't. We didn't used to talk about trauma-informed. We didn't used to talk about implicit and explicit bias. We didn't used to talk about the ACEs. All these things have been developed in the years that I've been at the House of Ruth. So yes, let's require the judiciary to be trained. I know they do extensive training, and I hope you will look at what's already on their curriculum before you dictate to them what has to be in their curriculum. But let's give the judiciary and the trainers the flexibility to train on what's necessary at that time. For those reasons, I urge you to amend and pass HB 561. Thank you.
Lori Ruth, please.
Good afternoon, Mr. Chair, members of the committee. My name is Laurie Ruth. I'm the legal director at the Women's Law Center of Maryland. I completely agree with Ms. Smith and Ms. Lenig. I will just add that the bill does not mention magistrates, and certainly it should be amended to include magistrates who hear a large percentage of family law cases, so that they receive whatever training. But I also urge favorable with amendments. I also agree that they should have appropriate training. I think the experts should be advising and deciding what that training should consist of, and the bill should be amended to take out a lot of that language that tries to specify in what you will hear from the opposition, I think thinks is a too guided of a way towards certain results. And I appreciate Delegate Fisher's work and thoughtfulness about this, and her concept that we don't train people's minds and we're not making them make a certain decision, but the language may suggest otherwise to some. So for those reasons, we urge favorable with amendments. Thank you.
Thank you. Melanie Shapiro, please.
Thank you, Mr. Chairman, Mr. Vice Chair, members of the committee. Melanie Shapiro, Public Policy Director with the Maryland Network Against Domestic Violence. Just want to echo what my fellow panelists have already testified to. We absolutely support the intent of the bill and judicial training. However, our concern primarily lies with the list of trainings that need to be held. As Delegate Davis indicated previously, the training changes immensely. When I first started as a practicing attorney doing juvenile cases, I did a week of training. And 10 years later, none of that training, quite frankly, all the terminology had changed. Everything, the basis was still the same. And we have legislation every year that's introduced to change terminology because of research that has evolved. For example, using the term behavioral health to update the language. And I thank Ms. Ruth for indicating that the magistrates need to be trained as well. District court judges also have the ability to make custody decisions in protective order hearings. And so where this is placed in the law, it does not necessarily include everybody who's making custody decisions. So look forward to working with Delegate Fisher to getting a bill that we can pass. Thank you very much.
Thank you. Maria Villamar, please.
Thank you. Good afternoon, Mr. Chairman, Mr. Vice Chair, and members of the committee. My name is Nina Villamar with the Office of the Public Defender. I too was a member of the legislative work group that studied court processes in cases involving child abuse and domestic violence. But I'm also the chief of the Parental Defense Division of the Office of the Public Defender. We represent parents whose children have been or are about to be separated from them by the Department of Social Services due to allegations of abuse or neglect. Many of our cases involve child abuse and domestic violence. So even though House Bill 561 specifically pertains to private family disputes, this affects the parents that are involved in our cases because the same judges handle those cases as well. So we have three amendments that I'd like to highlight, and the rest of them are covered in our written testimony. The first is that we agree that magistrates should be required to be trained as well, because they preside over family law cases and they make recommended findings of facts and make recommendations to the judges about what the ruling should be. Second, we ask that the subsection about parental alienation be deleted. This bill's language presumes that parental alienation does not happen, yet every one of us who has handled a custody dispute or has witnessed a bitter divorce has seen it happen in varying degrees. The way the bill is phrased is one-sided on this controversial issue, and we recommend that it be deleted. Third, train judges and magistrates about why an adult victim of domestic violence may not leave or report the abusive partner. This is critical because the Department of Social Services considers it to be a form of neglect by the abused parent for not leaving the abuser. And then DSS uses it as a reason to separate the child from the parent, which then compounds the trauma to the child. One last point is that we as attorneys who represent parents and children who are involved in these cases every single day receive training on these subjects so that we can gain a thorough understanding of this complex issue. The resistance to this type of training for the judiciary is very perplexing because no matter how well trained we attorneys are, it will all be for naught if the judiciary lacks the same understanding of the issues. So for these and other reasons outlined in our written testimony, the Office of the Public Defender urges the favorable amendments. Thank you.
Thank you. Delegate Eric to begin, then Delegate Carden.
Thank you, Mr. Chair, and thanks panelists for being here. I'm just wondering of the not OPD, but the other organizations that spoke, do you guys all litigate cases with child abuse? Is that something that's offered?
So we litigate primarily intimate partner violence cases. We do have a project with that does long-term custody, and there is often allegations. There are often allegations of child abuse, and as Ms. Lennick alluded to, living in a household with an abuser can also be damaging to a child. So while it might not be physical child abuse, that's a dynamic that we face pretty much in every case. We only represent victims of domestic violence, so in every case, that's a possibility.
And does the House of Ruth do that as well?
Yes, we have 4 full-time attorneys who represent folks in family law cases, so divorce cases or custody cases, depending on whether they're married or not. And we don't represent cases where it's just child abuse. There has to be a companion domestic violence case, but there's certainly child abuse in many of our cases.
Okay, so custody cases mostly.
Yes.
Or no? Okay.
Yes, custody cases and divorce cases if they're married that have a custody component.
Yeah, okay. So maybe a little bit different. My other question was, you had mentioned that you help with judicial training. Could you just tell us how many hours they get right now?
Well, I don't work with I work with the Judicial College when they specifically ask us to do a training. So this past fall in October, we did a training on the impact of trauma on kids in domestic violence cases. And so it was, I trained with one of the litigating attorneys who handles divorce and custody cases, and then 2 psychologists who you've probably seen testify here before who do a lot of custody evaluations. And the 4 of us did a pretty extensive training. It was 4 hours, but that's just one component from the judicial conference. You would have to ask them to give you their whole curriculum. I mean, they have a whole listing of everything that they offer in the college.
Okay, all right, thank you.
Delegate Carden.
Thank you, Mr. Chair. Just real quickly, this is to Ms. Ruth, Ms. Shapiro, and Ms. Lenning. If the State Bar Association gave pretty specific amendments in their written testimony, I think Ms. Smith mentioned them. I'd asked earlier about those to the people on the who were in favor of the bill. If we adopted those amendments, if Delegate Fisher was okay with those amendments, would you guys be okay with the bill as long as we included magistrates, Ms. Ruth?
Certainly, I think you should include magistrates. I'm not sure what the specifics were. I know I've spoken with Ms. Smith and others on the section, so I can't say specifically. I agree. I think part of the section, and Ms. Smith might be able to say, is problem with the term parental alienation has been discussed, and the cross-filer has agreed to amend that out. So if that may be an agreement on your side of the street, I'm not sure, and we certainly agree with that. But I would maintain the position that we take all of those specifics out and allow the experts to devise the proper curriculum in a more science-based, less advocacy-based framework.
Are there further questions for this panel? All right, seeing none, we thank you all very much for your testimony, and we'll go to the one person in opposition to the bill, Vince McAvoy. Mr. McAvoy.
Thank you, committee. Appreciate that. This bill I spoke to in JPR, and the people who are asking to train the judges are the same as you've been seeing for decades. You've been lied to. I've been telling you that their assertions are wrong, based, and misguided. And you know why each judge, child abuse grifter or child abuse center isn't on 300 Gay Street where I worked? Because there's never any child support, alimony, family law court dollars there. How do I know this? This bill has the stench of Susan Lee's SB 567. Your former colleague, Senator Carter, asked for a father's right advocate to be part of this. It was not added. The bill proceeded, and now you see what you have. You just received an email about a second ago where in JPR, you're told you can gut the entire bill except for the part where we train the judges, where we get paid. This is loaded with grift. It's a contrived point since its inception back in 2019. I've been saying this bill should be struck down in its entirety. No one can agree on this because it's not about the actual product. It's about getting the money. Fed dollars were just brought up. This child abuse has been going on for a very, very long time. If these people are saying that you need training, but you somehow can't send them a glossy with details, but they have to go there, they have to do it in person to get paid, you know where the issue is. If this was really about child abuse, they will be sending their literature and informing judges. And to say that the judges aren't informed, we must have a real problem. If we're paying these judges, they're just lining up for a raise this year. They're just lining up for a raise this year, $20,000. Thank you.
Thank you.
This is unconscionable that they would get a raise, but not no child abuse. Thank you for your time.
Are there questions for Mr. McAvoy? Seeing none, we thank you very much. And that concludes the testimony on House Bill 561. Now we're going to go to the Chair of Ways and Means, House Bill 639. And we'll hear her bill now. Welcome her back to the committee again, because she abandoned us. And we will hear from her, from Michelle Smith, Dorothy Lennig, Laurie Ruth, and Peter Markuski. We'll hear from all of them on House Bill 639. It's new, so 3 minutes for Chair Atterbury, 2 minutes for everybody else. Off we go, Chair Atterbury.
Thank you. I would never abandon you. I love you, Chair Clippinger. I love all of you, but I got a good offer. I won't be 3 minutes. I know you don't want to hear me speak for 3 minutes. I would just ask for a favorable report on House Bill 639. I just want to take this opportunity to thank Michelle Smith and the family law section of the bar for working very hard on a work group during the interim with former Delegate Kathleen Dumais and other members that you will hear about. Members who are returning to this committee this year, I want to thank you. For the past 3 years, you passed a bill that just focused on divorce in terms of individuals who lived in the same house being able to get a divorce. This is expanded this year. And I believe, I hope I'm not misspeaking, but the Bar Association felt very strongly, and I agree, that we should just revamp our antiquated divorce laws. And so what this bill does is move to irreconcilable differences and gets rid of all of the specific grounds for divorce. I did a quick count, and there are 31 other states that use the term irretrievably broken or irreconcilable differences. So we would not be new in that sense. The bill keeps the language that this committee worked on very hard for 3 years. I'm sure some of you remember, in terms of being able to live in the same house and get a divorce. What is so difficult is for some individuals, particularly those in a domestic violence situation or an abusive situation, you can't afford to break and create your own household just so that you can get a divorce. And this will help those individuals. I also want to point out that Delegate Crutchfield, who I'm sure this is probably headed her way, was able to join in on some of those meetings. So I appreciate her participation on that as well. And with that, I will end, Mr. Chair, and I'm happy to answer any questions from the committee. Thank you.
All right, we'll hear 2 minutes from Michelle Smith now.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. I am Michelle Smith. I am here on behalf of the Maryland State Bar Association Family Law Section Council. We support House Bill 639 and appreciate Madam Chair Atterbury's leadership as well as Delegate Crutchfield's leadership on this important bill. HB 639 will streamline Maryland's current divorce law to allow our citizens to file for and obtain divorces with less waiting time, less expense, and less acrimony within families. HB 639 will eliminate the confusing and little used category of limited divorce, which I'd be happy to answer questions about. It will eliminate the required grounds of desertion, adultery, cruelty of treatment, and excessively vicious conduct. It will shorten the required 12-month separation ground to a 6-month separation ground, and it will codify law that's case law that allows parties who have pursued separate lives to be deemed to have lived separate and apart, even if they have been residing under the same roof because they simply can't afford to do otherwise. Under House Bill 639, Marylanders will be able to file for divorce based on several grounds. First one is 6 months separation, even if they're living under the same roof. Second one is allegation of one party that there are irreconcilable differences upon which the marriage should be terminated. Third is permanent legal incapacity of one party who lacks the legal capacity to make decisions. That was already in our law. And 4, mutual consent if the parties have submitted a written signed agreement resolving all the issues with alimony, distribution of property, custody, and child support, already in the law. This bill will bring Maryland in line with many other states. I would echo Chair Atterbury's comments. There's at least, last time we looked, 31 states that talk about either irreconcilable differences or irretrievably broken, and 39 if you add in incompatibility, which in my mind, those 3 things encompass the same facts. This will change our law, which is based primarily on fault grounds, such as adultery, desertion, cruelty. It will simply allow Marylanders who are in unhappy marriages immediate access to the court to begin the process of dissolving their marriage and moving on with their lives. In our court system right now with COVID, sometimes it takes up to 2 years or more to resolve an average divorce case. This is a timely bill, which will allow people who do not wish to allege or cannot prove these fault grounds, or who don't want to live separately or can't afford to get their cases started. Yes, Mr. Chair.
All right.
We urge a favorable report to House Bill 639. Happy to answer questions.
All right, thank you. We'll go to Dorothy Lenig for 2 minutes.
Thank you, Mr. Chairman, Mr. Vice Chairman, members of the committee. My name is Dorothy Lenig. I'm the director of the Domestic Violence Legal Clinic at the House of Ruth. House of Ruth strongly supports this bill and thanks Chair, and I love saying that, Atterbury, for bringing this bill back several times. Ms. Smith just did a wonderful job of describing what the bill does. So all I'm going to say that it's really helps survivors of domestic violence. They would no longer have to prove cruelty of treatment or excessively vicious conduct in order to be able to get divorced, which I think would really lower the temperature a lot on these in contested divorce cases. It would just make it easier. And almost all of the House of Ruth's clients have limited resources and often have trouble living apart before the divorce. They just can't afford it. So this would give at least some people the opportunity to live separately within the same house as they're moving towards the divorce. If it's important to the parties to talk about the fault that occurred in the divorce, all of those issues could come up as they are relevant to things like custody or alimony or marital property. So I think this really brings us into the 21st century and is so important and would be a huge step forward. We urge a favorable report on House Bill 639. Thank you.
Laurie Ruth for 2 minutes, please.
Good afternoon, Mr. Chair, members of the committee. My name is Laurie Ruth. I'm the legal director at the Women's Law Center of Maryland. Ms. Smith did a terrific job, as did Ms. Lenig. I just want to add from our perspective, the Women's Law Center staffs and runs the statewide family law hotline. We talk to about 6,000 pro se litigants a year. And this bill, for me, would have a tremendously positive effect for a large number of Marylanders. When I look at all the bills we're doing this year, this is the one I think that is well beyond necessary. We really need to update our divorce laws to come into the 21st century. Some of our current divorce laws are rooted probably later back than the 20th century, certainly. So for self-represented litigants, you know, they call up, they don't know how to unentangle because they don't have the money to live in separate residences, as was mentioned. They don't understand the concept of limited divorce. We spend a lot of time on something that really has no real effect for the majority of people who may start their cases in limited divorce. And as Ms. Smith said, I'm happy to answer any questions about that. And, you know, just to reiterate this concept, we're not reinventing the wheel here, bringing irreconcilable differences into our law. So, you know, for those reasons, and really for those self-represented litigants, I think we know that in over 80% of family law cases, at least one party is unrepresented. This would really simplify their access to the court system to help them resolve the issues that need resolution. It's never really the ground for divorce that's the problem. It's the things that Ms. Lenig mentioned. It might be alimony, child support, et cetera. But the ground for divorce has really never been the real problem. And we should just get rid of that layer of things that keeps people from being able to access the court. So for those systems, we urge a strong favorable report for this bill. Thank you.
Peter Markuski, please, for 2 minutes.
I'll try. I'm Peter Markuski, and I am the chair of the Family and Juvenile Law section of the Maryland State Bar Association. And I'm going to try not to reiterate what Michelle, Dorothy, Laura, and everybody else, and the delegate Attenberry, Chair Atterbury have said. But I've been doing practicing in the family law area for, I should say, 40 years. And in that period of time, I've actually gone to trial and been successful in getting one limited divorce out of the thousands of cases that I filed. So this bill eliminates the need and the term limited divorce. Of the divorce filings that have been filed over the last 3 years, less than 6% of those filings have been in limited divorce. And the only reason we ever file for a limited divorce if we don't have the time limit to file for an absolute divorce. And I've been involved in the self-help with pro se litigants, and it's very difficult to explain to them what the difference is between a limited divorce and an absolute divorce is. And in speaking with magistrates throughout the state, oftentimes the two pro se litigants can't go forward because they've filed either a limited and should have been absolute, or an absolute and the limited. And the role of the magistrate is not to tell the people how they should file their pleadings. And many cases get delayed or get dismissed because of improper filings. We can eliminate all of that and make it easier and make the system more accessible and shorten the backlog for these cases. As Ms. Smith said, it often takes, and 2 years is lucky. I'm on one case that's been over 3 years and we still haven't gotten to trial because of continuances related to COVID. But I think it's important. And one of the goals when I became chair is I wanted to amend, or as Michelle Smith or somebody said, bring our divorce grounds into the 21st century and make us consistent with many of the other jurisdictions throughout the country.
Mr. Markuski, we'll need you to begin to wrap up, please.
All right, thank you. And I'm happy to answer any questions of anybody.
Great. Are there questions for the panel? Delegate Bartlett.
Thank you, Mr. Chair, and thank you everyone for coming in to testify. I have a quick question for Madam Chair. I get it, and there's been a lot of work, and I understand that, and I appreciate it. I see that the imprisonment part that we used to have is gone, And so I'm assuming that if someone's been, I'm assuming that's incorporated with the 6-month separation. Is that what happened with it? So okay, all right. And then there was one more question I had. So all these other grounds of cruelty and all that is just gone. You've just been separated for 6 months, you're good to go, right? I'm seeing heads nodding, so I appreciate, thank you for helping me with that.
I'm happy to answer, but I don't want to step on anybody else's toes.
No, go ahead, Ms. Smith.
Okay, thank you. Yes, Delegate Bartlett, they're gone in the sense that you no longer need them for your ticket to the courthouse door, but they are not gone in the sense that if those facts, unfortunately, are present in a case, then they still will be part of a complaint. They will be argued to the judge. They will be grounds for the judge to make decisions on child custody, alimony, monetary award, all kinds of things in the divorce or custody matter. You just don't have to have them in order to get access to the court anymore.
Okay, I understand. And another quick question, and this is from Ms. Smith, I suppose. Can one get a divorce without the other spouse? Is that a possibility?
You have to be married. I know you don't mean that, but what do you mean without the other spouse?
Can you go into court on your own without the other spouse being being present? Like maybe they're in the military or something, okay? And so, but before he went away to the military, or whatever, you all were separated apart and all, for 6 months. Could you be granted an absolute divorce in that case? Circumstance.
The short answer is yes. The longer answer is you have to serve the other party. So the other party has to be aware of it. If the other party is in the military, they can evoke a delay procedure. The court is really not going to give somebody an ex parte divorce without trying very hard to make sure that the other party is aware and gets the chance to speak on the issue. There are default divorces, but you have to go through a very tedious procedure in order for that to happen. So nobody's sneaking around getting a divorce behind their spouse's back, in my experience.
Okay, great. That's what I wanted to know. Thank you very much. I got my divorce in California, so I understand. Thanks.
Delegate Erica.
Thanks, Mr. Chair. This question is for Madam Chair. So I could have sworn that we changed it to 6 months before. Did this a Senate problem? Did it get caught up on the Senate side or something?
So the first 2 years, the Senate didn't take it up. Last year, it got caught in the, continuous movie that you all see between JPR, and they did pass it, but it was like, you could see it on the screen and it died on sine die, that the whole Senate didn't vote on it.
Okay, that explains that. And I'll just add that I know 2 people now that are getting a divorce and are living in the same home, but one in the basement. So it's definitely helped families already that we fixed that. So good job on that one.
Are there further questions for the panel? Seeing none, we thank you all very much for your testimony today, and we'll hear from the one person in opposition, and that is Vince McAvoy. We'll hear from him for 2 minutes. Mr. McAvoy. Two minutes, please, Mr. McAvoy.
Thank you so much, committee. I remember Senator Gasly, he put this much more eloquently than I did, but he basically likened marriage now in Maryland to something that you get through a drive-through restaurant. That basically you go in and you apply for it. You can they're trying to make it do it online, and then you can erase it as quickly. So I think that this bill erases the whole issue of the concept of a sacrament of marriage, that it negates that entire thing. But I just think that there's a lot of logistics that are going to be involved with this, including having this happen within 6 months within the same tax year, which will probably lead to a lot of confusion. The bar has brought this up in previous years, that less than a year presents a lot of logistical concerns. And so I know there's this tendency to paint all divorces as a domestic violence related or somehow contested. People get divorced for different reasons, and this sort of one flavor fitting all is just not really what the entire state of Maryland needs, and it will cheapen the concept of marriage in this state. So for that reason, I urge and in favor. Well, thank you for your time.
Are there any questions for Mr. McAvoy? Seeing none, we thank you very much. That concludes the testimony on House Bill 639. Thank you. We'll go now to House Bill 833, I think. That's where I'm supposed to go, right? There's Delegate Learman, yes. Delegate Learman's bill, it's a new-ish bill, but we're giving her 3 minutes and everybody else 2 to testify. And we'll hear from Melanie Shapiro, Jessica Emerson, Amelia Rubenstein, and Elizabeth Kimball for the first panel. All right. So Delegate Learman for 3 minutes, please.
Thank you. It's great to be here with you all for my final stint in judiciary. Couldn't let my teammate go without having to deal with me once more. Great to be with you all. In 2017, the Maryland Safe Harbor Work Group, chaired by Governor Hogan's Secretary of Smith, John Wobensmith, issued a report on how to ensure that Maryland is a state that supports victims of sex trafficking and works to help reintegrate them to be successful survivors. Out of that report, I was proud to bring legislation in 2018 based on the top recommendations of that report. 1, to create a safe harbor for youth victims of trafficking, and 2, to set up a system of regional navigators to ensure that no victim falls through the cracks. Well, the state's attorneys expressed concern that the regional navigator system had not yet been set up so that any safe harbor provisions shouldn't be created until after that. This committee agreed, and we worked to pass a bill to create the regional navigator system that operates around the state today. It's been several years. The navigator system is up and running and functioning well. The navigator organizations have seen how the system works. Advocates have seen how things are going, and they all believe that there is more work to do to ensure that Maryland joins the 40 plus other states in this country that have laws that divert victims of sex trafficking away from the juvenile justice process. So this legislation will strengthen Maryland law to support juvenile trafficking survivors by recognizing the impact of trafficking and trauma on their behavior. It does a few things. It requires law enforcement officers to notify an appropriate regional navigator for the jurisdiction where the victim was taken into custody. It requires a court to stay any proceedings and to notify a regional navigator to evaluate a victim's status if there's any reason to believe that that person is a survivor of sex trafficking. It requires a court to dismiss a case if a regional navigator finds that the victim committed a violation as a result of being trafficked. It provides safe harbor at the end of the day for a victim from criminal prosecution or from being proceeded against as a delinquent for a crime or civil offense. That's one of a qualifying offense. We have submitted several amendments to the amendments office that will address some of the points raised by the Department of Human Services and clarify references to the vacatur list as quote, qualifying offenses. This bill is just the right thing to do. It will lead to better outcomes for trafficking victims. It will improve resiliency for survivors, and it will ensure our justice system is focused on true offenders, not victims. Current state law in Maryland allows sex trafficked juveniles to be prosecuted and convicted for prostitutions and other crimes that they were forced to or coerced into committing as a result of their trafficking. So I urge a favorable report on HB 833 so that Maryland can finally join the 40 plus other states that does right by our trafficking victims and survivors. Thank you.
All right. Melanie Shapiro for 2 minutes, please.
Thank you, Mr. Chairman, Mr. Vice Chair, members of the committee, Melanie Shapiro with the Maryland Network Against Domestic Violence. And thank you to Delegate Learman for being such a champion on this topic. 14 years, it was 14 years ago in June of 2008, when New York passed the first safe harbor law in the country, recognizing what to me is common sense. Child victims of sex trafficking should not be charged with the very offense that makes them a victim. It was actually the first piece of legislation I ever worked on. Since 2008, 27 states in Washington, D.C. have passed similar laws providing safe harbor to child victims of sex trafficking. And other states have laws that divert cases from the juvenile justice process. That's 42 states in Washington, D.C. that have better laws than Maryland for child victims of sex trafficking. Maryland stands in an unfortunate category of not only receiving an F by Shared Hope International on their state report cards released at the end of 2021, but also is ranked in the bottom 10 states for treatment of child victims of sex trafficking. 7 years ago, in 2015, the Maryland Work Group to Study Safe Harbor Policy for Youth Victims of Human Trafficking was statutorily created. The first recommendation from the first report of the work group is to provide safe harbor for youth aged 17 and under who are charged with prostitution or prostitution-related charges with immediate referral to services. The regional navigators were established to provide services to child victims of sex trafficking, and we have long recognized sex trafficking as a form of child abuse. Yet our laws still permit those children to be charged in court. I will not share the stories of the young people who were victims of trafficking. You will hear from survivors yourself. But what I will share is that the absence of safe harbor protections absolutely prevents children from disclosing their victimization or acceptance of services because they could be subject to prosecution and punishment. Prosecution and punishment for being victimized in ways that are hard to comprehend. MNADV supports this bill not only because we believe this should be Maryland law, but because of the undeniable intersections of child sex trafficking and domestic violence. In addition to the similar power and control dynamics, it is all too common for a trafficker to be a boyfriend or intimate partner of the victim. It's time for Maryland to do better. We must treat our child victims of sex trafficking as the victims and survivors they are. And we urge a favorable report on House Bill 833.
Thank you. Jessica Emerson, please.
Yes, good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. My name is Jessica Emerson and I direct the Human Trafficking Prevention Project. I'm also here in support of House Bill 833 with the sponsor amendments. Like Melanie, I was also there 14 years ago when New York State passed Safe Harbor. My job title was different then. I was an adolescent social worker, but my focus was the same then as it is today. And I remember prepping client after client, helping them describe the harms they experienced on the streets and at the hands of their traffickers, and then at the hands of a system that was set up allegedly to bring justice on their behalf as victims of crime. There was Caroline, who had gotten HIV from her trafficker and had been charged numerous times with prostitution. There was Catherine, who reacted to a lifetime of trauma by acting out against others and was arrested multiple times for assault. There was Monique, who had been kicked out of her house at the age of 13 for being transgender. So in addition to prostitution, she also had a juvenile record for theft and several other survival-based crimes. These young people all had different stories of how they got to me, but what united them was the deep, unyielding feeling of betrayal they felt knowing that the system set in place to protect them routinely failed to do so. While they tended to view their trafficking as an extension of the abuse that each of them had endured throughout their childhoods, their experience with the legal system was that harming them was a conscious choice made by a system that saw them as entirely unredeemable and to blame for what had happened to them, or on the off chance that someone actually recognized their victimization, chose to use them only as a tool to prosecute their traffickers, throwing them back in jail if they refused to cooperate. Let me be crystal clear with this committee. Incarcerating youth for being the victim of a crime which involves chronic abuse and sexual assault does nothing other than serve to tighten their traffickers' control over them and their reliance on the streets. I ask that you trust the survivors of trafficking you will hear from today and those of us who have dedicated our lives to them. Trust us when we say that incarceration is not the way to protect these youth, that they are commonly forced to commit a variety of crimes as a means of survival, and that they are not more likely to cooperate with prosecutors if threatened with jail time. Do not let this body be yet another system that fails them. Thank you.
Oh, you're on mute, Mr. Chair.
It's fighting with me more than usual. So we're going to hear from Amelia Rubenstein next, then Elizabeth Kimball. We're also going to hear from Lisa Jordan after that. So Amelia Rubenstein, please.
Good afternoon, Chairman Clippinger, Vice Chairman Moon, and the Judiciary Committee. My name is Amelia Rubenstein. I'm the Director of Research and Programs at the University of Maryland Safe Center, where we provide direct services for survivors of sex and labor trafficking. I'm a licensed social worker. I've been practicing in Maryland with survivors of child sex trafficking, in particular for the last 10 years. Our agency also serves as the regional navigator for Montgomery and Prince George's County, where we work to identify child and youth victims of sex trafficking and then ensure that those youth are connected to trauma-informed care. So we've seen firsthand how trafficked youth are often criminalized as a result of their trafficking. My colleagues are going to cover a lot of things. The one critical data point that I do want to share with you is that between 2010 and 2020 in Maryland, there was 110 arrests for prostitution and commercialized vice of minor children. So let that sink in. We are arresting children for prostitution. Of those arrests, 33 of them were for children 15 years old and younger. So this is an unacceptable response to young people who are already defined by federal and state law as victims of sex trafficking who require immediate intervention. These youth require child welfare rather than juvenile justice response to ensure that they are safe, stable, and connected to proper trauma-specific treatment. HB 833 builds on Maryland's critical 2019 child sex trafficking screening and services law that established the Regional Navigator Program, which we are currently enacting, and expanded services to victims of sex trafficking. Now we require this additional legal protection to ensure that children cannot be charged with the very crimes of which they are a victim. This critical protection would ensure that Maryland finally has a true safe harbor law. For these reasons, the University of Maryland Safe Center respectfully requests a favorable report on HB 833. Thank you.
Thank you very much. We'll go now to Elizabeth Kimball, please, for 2 minutes.
Hello, my name is Liz Kimball. I am here today not as the professional I have fought to become, but as the survivor, sharing a story I have fought diligently to put behind me. By the time I met my first trafficker, I'd already been groomed for him through survival sex and parental abandonment after my father's passing. The work was effortless on his end. At 15 years old, I was in a relationship with a man who was physically forcing me from his vehicle onto the streets to make money for him at the expense of my body and soul. Each night I would walk the streets in the DC metro area and take calls from Craigslist, where I would be brought into affluent homes and affluent neighborhoods, many of which I'm sure some of you in this room are familiar with or even live in. I endured this horror for nearly a year, lying beneath man after man, being raped nearly 2,700 times. Although I wanted help, my traffickers told me no one would care. You're the criminal, they said. In addition to committing forced acts of prostitution, I was also forced to commit theft, often to obtain the survival needs my trafficker denied me, such as tampons. I was also forced to fight often, as the culture of victimhood is commonly violent and demands confrontation for survival. And what did the police do when they encountered me? They arrested me, calling me a whore. They didn't see a 15-year-old child who had been raped approximately 50 times that week. I don't believe they even saw me as human. And what did the criminal justice system do when they encountered me? They held me in lockup overnight, handcuffed to another small child. When I met the prosecutor, they told me that in order to keep my siblings from going to foster care and my mother from going to jail, I would have to testify against my trafficker, who I both loved and feared. I was discarded and then sentenced for an act I couldn't legally consent to. From police to judge, all had the opportunity to intervene, to help, to offer me protection. Instead, they simply reinforced the narrative my trafficker had sold me. I was the criminal. After I'm done testifying, our opponents will stand before you and tell you that the millions of other children enduring the same systemic failures that I did don't deserve to be free, not from being arrested, prosecuted, and sentenced as criminals for acts we're forced to commit by our traffickers. They will tell you that we need to be locked up to get help and to be saved. This view is inaccurate, ineffective, and emblematic of the deep flaws that exist within the criminal justice system. You have the power to change this. This bill is about shifting perspective, about allowing victims to be the experts in our own lives. I ask that you consider the impact this safe harbor bill can have and how it could potentially save the lives and futures of the children we serve. I ask for a favorable report on House Bill 833. Thank you.
Thank you very much. Lisa Jordan, please.
Thank you, Mr. Chair, Mr. Vice Chair. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in support of House Bill 833 with sponsor amendments. Thank you, Delegate Learman, for your continued passion and advocacy on behalf of this population. The Maryland Coalition Against Sexual Assault, as you know, is the coalition of rape crisis centers across the state of Maryland. We're also home to the CAST project, Coordinated Action Against Sex Trafficking, which helps to develop sex trafficking response at the rape crisis centers. And we firmly believe that sex trafficking is a form of sexual violence that we all need to work on to end. We still have far to go, and House Bill 833 is an important next step. I've been tasked with explaining to the committee some of the technical pieces of the bill and the amendments. So first off, this bill prevents prosecution for certain crimes, but not for every crime, not for violent crimes. The crimes that could not be prosecuted if the minor is a victim of sex crimes include status offenses, which are defined by the amendments. And these are offenses where the only reason it's a crime is because someone is under the age of 18, such as truancy. Qualifying offenses, which is a term that is defined by our vacator law. So that's a long list of crimes. And then there are two additions to that qualifying offenses. One is unauthorized use of a motor vehicle, which is frequently a charge that's placed against survivors of sex trafficking. And then the other is soliciting, but not purchasing prostitution. As you've already heard, sex trafficking itself is also something that children would not be able to be prosecuted for, and that's because adult traffickers use minors who work for them to manage their other youth. Other amendments make changes in the process to make sure that regional navigators are helping children and not investigating children. It's also important to note there are some things the bill does not do. It does not really address sexual exploitation where a pimp is not involved. Our laws in general are fairly inadequate in that population. It does not adequately address youth who are 18 to 24. These victims are provided with services under our Safe Harbor Services program, but this bill is about prosecution and juvenile proceedings against minors, and it does not address crimes where there's another human being who is a victim. So it's not assault, it's not crimes against other people, where of course there are crime victims' rights where we need to address these crimes, but not say we can't prosecute them at all. Those need to be addressed in other ways. Each of these issues is important, should be addressed. For those of you who return next session, I urge you to consider addressing them, but we respectfully ask you to pass House Bill 833 with the sponsor amendment so we continue to make progress. Thank you, Mr. Chair.
Thank you. Delegate Shetty with a question.
Thank you, Mr. Chair. Thank you, Delegate Learman, for bringing this important bill. I have a quick question for Ms. Shapiro, if I may. Have you had a chance yet to take a look at the opposition from the judiciary in particular, and do you have any thoughts that you can share with us?
Thank you so much for that question, Delegate Shetty. I did have an opportunity to look at their opposition. I would note that in their opposition testimony, they write that they strongly support the intention of the bill. They have a few technical concerns. Some of them have already been addressed in the amendments that Delegate Learman are putting in and that Ms. Jordan so eloquently explained. The process, one of the challenges with child victims of sex trafficking is they often come into court on other charges. And that's one of the things that this bill addresses. And we don't always know that they are victims of trafficking. And it might be some time because as Ms. Kimball explained, they might be distrustful of the system, and the system sometimes causes harm. And so we've established a process that actually mirrors what's already done for competency for children in the juvenile justice system. So there are a few technical issues that the judiciary raised in their testimony. I think that we are absolutely able to address them if there's any concern, but the process that was utilized is actually one that already exists, because competency can be raised at any time in a case by any party. The case gets put on hold while it's determined. So in this case, the court would determine whether or not a child was a victim of trafficking. And if they were, then the case would be dismissed. And so I look forward to working with them, to coming up to see if there's any technical fixes that need to be made. But I would thank them for indicating their strong support for the intention of the bill. And I think that we can resolve any of their concerns.
Delegate Cardin.
Thank you, Mr. Chair. Very quickly, for Delegate Learman, thank you for bringing this very good bill and all the compelling testimony of your witnesses. I am just curious, you talked passionately about these regional navigators and how we need to take advantage of them based on the study or the work group. Is it my understanding that we've created this whole system of regional navigators, but we're not requiring whether it be law enforcement or courts or state's attorneys to inform those navigators of and that's what this bill is trying to do. Like we set this whole program up, but we're not, at this point, we still don't require them to be informed of these young people that are being so mistreated.
So it's a great question, and we're going to have, I believe, Amanda Rodriguez is at some point testifying and has testimony on behalf of all of the navigators. It's not required right now. They're there as a resource, and they are being well used, but this seeks to strengthen the system. Yep.
Delegate Munoz.
Thank you, Mr. Chair. I do not speak up often in committee, but I am going to ask for the chair's indulgence and the committee's indulgence just to take a moment to thank Ms. Kimball for coming and speaking to us today. We hear from a lot of people all across the state on a lot of difficult and painful issues in this committee, and having the bravery to come and speak with us and share your story today can change votes and can change law in Maryland. So I just wanted to commend you on your bravery and thank you for coming today.
Thank you.
Are there further questions for this panel? Delegate Grammer.
Thank you, Mr. Chair. So I just want to make sure I'm reading this properly. So if under this bill, if passed, it was found that the suspect was a victim of sex trafficking, this would provide them immunity. Am I reading this correct?
Well, it's a little, I mean, it's almost, how it's termed is it basically provides a safe harbor for them. So it says, they can, that the court will dismiss that provision if it's found that they're doing it as a result of their trafficking. And at that point, either their parents would come or DHS would take over, or, whatever other process would happen. The regional navigators would be there for them to help them as well.
So not exclusively immunity, but pretty close. And I just wanted to have someone speak to this. Not all of the crimes listed under qualifying offense are completely victimless crimes. Why, in this case, is it necessary to have near immunity under this bill? Can somebody talk to me about, because you have malicious destruction of property, burglary, misdemeanor theft. So it's not completely victimless crimes. Why is it necessary here to have such strong near immunity? Can someone speak to that, please?
Sure, I can start, and then I'm sure Lisa and Melanie or Jessica will have things to add. So first, we start with the vacatur list, right, which are qualifying offenses, which this committee and the General Assembly has already found that those crimes are things that should be able to be vacated, right? So we start with the vacatur list, and then we looked at the most common types of crimes that our trafficking victims are forced to commit, right? So like, a trespass, or as you heard testimony on, like shoplifting tampons, right? Those sorts of crimes, technically shoplifting, I mean, there is it's not maybe always victimless because of the store, but it's something that just happens over and over again. And at the end of the day, this is a victim who's doing it, and they're not doing it of their own volition. They're doing it because they're being forced to do it. It's a direct result of their trafficking status. I'm guessing Lisa or Jess or others will have more to say about that.
Please.
Yeah, Delegate Grammer, I appreciate that question. I think that you're correct. They're not all victimless crimes. Many are near to victimless crimes and none are crimes against a person. So you would note that assault's not on there or those sorts of crimes. But I really think that Delegate Learman has really articulated the policy. This body, the legislature, has already said that for people who are convicted of these crimes on this list of qualifying offenses, including the crimes you're pointing to, the theft, the lower level crimes, they can vacate their conviction. And so it seemed important to make this parallel. And in some ways, I would even suggest it's more efficient, right? Because we don't want to say, okay, let's convict them and then allow them to vacate. We just can say, let's recognize this at the outset and provide the services that these kids so desperately need as soon as we can. Keep them out of the system. Don't waste those resources. Make sure that we're really addressing these kids' needs. So that's how this list was come to, is that we were thinking this is something the legislature has already approved, as when someone who is a survivor of sex trafficking, you've been convicted, you can get this vacated if it's a direct result. And I'm not sure that we've articulated that standard before, but that is the standard that is in the amended version. It needs to be a direct result. So it's not just that someone is arrested for a misdemeanor obtaining property or services by a bad check. It's that this happened as a direct result of the human trafficking. So that was negotiated with the prosecutors when the vacatur law was enacted. And so that was how we landed on that policy. And I really encourage you to look at it in that way, as a very balanced approach.
Yeah, I remember talking generally about this previously, and I believe we explored like an affirmative defense. But just curious as to how we came to this, but I appreciate the insight.
Thank you, Elliot.
Fighting with the machine today. All right. Are there further questions for this panel? Seeing none, thank you all very much, and we'll go to the next panel. Nadine Finnegan-Carr, Carolyn Ackerman, Haley Wolf, Nicole Hansen-Mundell, Amanda Rodriguez, and Christine Reyno. Hear from Nadine Finnegan-Carr, please. All right.
Good afternoon, everyone. I'm Nadine Finnegan-Carr. I hold dual appointments at the University of Maryland, Baltimore in both the schools of social work and medicine. And I'm the director of the Prevention of Adolescent Risks Initiative, where we have multiple federal grants to address the issue of domestic minor human trafficking in our state. I come before you in support of House Bill 833. Over the past decade, we have worked diligently in collaboration with the Maryland Human Trafficking Task Force and Maryland's Departments of Human Services and Juvenile Services to build the infrastructure for our state to address the issue of child sex trafficking. This work has included providing the training and technical assistance to the Regional Navigator Program. Currently, this program covers 10 jurisdictions, with the remaining jurisdictions expected to be covered by the end of this calendar year. As mentioned before, the 2017 Protecting Victims of Trafficking Act defined child sex trafficking and provided for youth who have experienced trafficking to receive a trauma-informed, child-centered response via the child welfare system, as opposed to the juvenile justice system. And this House bill would extend the protections available to child sex trafficking victims that were established by this 2017 Act and then codified in the Child Sex Trafficking Screening and Services Act of 2019 by providing additional protections, especially for those youth trafficking victims who have been charged with prostitution and other related crimes. Our team supports this bill because it protects, as opposed to criminalizes, the most vulnerable victims, the children here in Maryland, and provides them with much needed services. Traffickers often target these youth, runaway, homeless youth, as well as children who have been abused or neglected. And they force them to not only engage in commercial sex, which puts them at risk for prosecution, but also forces them to commit other crimes during their trafficking experience. When these child trafficking victims are convicted of prostitution or other crimes, they are often transferred from the control of a trafficker to the control of the juvenile justice system. Services that are currently being provided to Maryland youth who have experienced the trauma of trafficking do not extend to youth who may be incarcerated from these actions stemming from their trafficking experience. This safe harbor law will ensure that trafficked children are treated as the victims they are, not criminals, and provide access to things like medical care, safe housing, remedial education, and counseling services. Safe harbor laws protect child victims of trafficking from unjust criminalization. Further, because this
Dr.
law—
Finnegan-Carr, your time is about up.
Okay, for all of these reasons, we support, and please refer to our written testimony for anything else. Thank you.
Thank you very much. We'll go to Caroline Ackerman, please, for 2 minutes.
Good afternoon. My name is Caroline Ackerman, and I'm the managing attorney of Maryland Legal Services and Special Projects at the Amara Legal Center. The Amara Legal Center is a nonprofit that provides free trauma-informed legal services to individuals impacted by sex trafficking or involved in sex work in Maryland, DC, and Virginia. At Amara, we envision a society where our clients are free from stigma, violence, oppression, exploitation, and criminalization. Safe harbor is a key part of that vision. Amara commends the legislature for passing the Regional Navigator program in 2019. This program enables trafficked youth to receive specialized services and was the first step in recognizing that youth engaged in commercial sex are, by definition, survivors of sex trafficking. As the next step, Amara urges you to support HB 833, which would prevent minors from being prosecuted for offenses directly related to their trafficking victimization. As a result of the power and control exercised by traffickers, survivors may be coerced to engage in activities that they would not have otherwise engaged in. These activities may result in involvement with the criminal legal system. Now, youth, because of their age, are especially vulnerable to trafficking. According to the National Human Trafficking Hotline, in 2020, there were 41 reports of human trafficking involving minors in Maryland. We suspect that this number is even higher because many survivors are unable to access services or call the hotline. In sum, youth should not be criminalized for offenses committed while being trafficked, and HB 833 provides this protection from prosecution. In addition to the qualifying offenses listed in the criminal procedure article, Amara also supports amending the bill to include status offenses such as truancy or running away. These are common offenses that youth might face while being trafficked. Amara strongly supports HB 833, and we thank you for your time to share our thoughts with you today.
Thank you very much. Let's go now to Haley Wolf now for 2 minutes.
Thank you, Chair. Good afternoon, members of the Judiciary Committee. My name is Haley Wolf. I'm a law student at the University of Maryland, Carey School of Law, and an intern with the Maryland Network Against Domestic Violence. On behalf of MNADV, I urge a favorable report on House Bill 833. This bill is important to MNADV as the State Domestic Violence Coalition because many victims of human trafficking are trafficked by intimate partners or someone they believe to be an intimate partner. In 2021, ranked number 44 out of the 50 states and scored an F on Shared Hope's Child Sex Trafficking Report Card because of the many improvements needed to our state's response to trafficking, particularly the non-criminalization of prostitution offenses for trafficked youth. This bill is an opportunity for Maryland to catch up to the many other states who have already enacted similar safe harbor laws. Safe harbor laws such as HB 833 protect children who are victims of human trafficking instead of criminalizing them as prostitutes. The best way to keep these children safe is by ensuring that they are treated as victims, not as criminals. This approach encourages them to access the services that they desperately need. Prosecuting trafficked children, on the other hand, can put them in more danger by not only exposing them to the harms and trauma of the criminal legal system, but also by pushing them back into the arms of their trafficker. Knowing that they could be arrested and prosecuted leaves child victims distrustful of law enforcement and deters them from coming forward to seek help. Additionally, what we are dealing with in these cases is not prostitution, it is statutory rape. We should not prosecute children for prostitution when under Maryland law, they are incapable of giving consent in the first place. Even for minors over the statutory age limit, their consent to sexual acts in connection to their trafficking could not possibly have been freely given due to the fact that they've been trafficked into doing so. For these reasons, I respectfully request a favorable report on HB 833. Thank you.
Thank you very much. We don't see Nicole Hanson-Mundell in the room. We'll go now to Amanda Rodriguez, please.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. I'm Amanda Rodriguez. I'm the Executive Director of Turnaround, which is the first comprehensive victim service provider in the state for human trafficking survivors and the Baltimore County Regional Navigator. I'm also the chair of the Legislative Committee of the Maryland Human Trafficking Task Force. I was a prosecutor for 7 years in Baltimore County, where I handled some of the first human trafficking cases in the state. When I left the office, I'd prosecuted more human traffickers than anyone else in the state. And I also faced the harsh reality that I unknowingly had prosecuted a number of children who were, in fact, trafficking survivors. But even me, the resident expert on trafficking, missed them. This bill will lead to more prosecution of sex traffickers. Children who are threatened, forced, and coerced to engage in the system will resist and believe the lies the trafficker told them that they cannot trust the system. Children who are treated like victims are more likely to actively engage with law enforcement and prosecutors. There's a survivor who testified in one of my most impactful prosecutions, actually changed the entire trajectory of my career. I had initially threatened her with charges so that she would participate, and she fought hard against me. She was subjected to regular torture by her trafficker, but she stood by him because he was the only one that she could trust. When I offered her the option to testify or not and empowered her to actively engage in the system, the dynamic instantly changed. We are still regularly in touch years after her trafficker was put behind bars, and she's now a successful woman, a wife, and a mother. A number of groups have reached out to us to ask questions and get clarification. As an example, the chiefs and sheriffs recently reached out regarding some language in the bill. After our conversation, they have no further concerns. We have yet to hear from any group that has opposition or concerns to the substance of this bill. In fact, the sergeant on that call who regularly works these cases said no one wants to lock up child sex trafficking victims. And just as I finish up, I know Delegate Cardin asked regarding the regional navigators. So current law requires that DSS and law enforcement refer to the regional navigators, although as the regional navigator in Baltimore County, I can say that we've received no referrals from law enforcement, but many from our DSS partners. They're the only two that are required by law. Thank you.
All right, thank you very much. Okay. We'll go to Christine Rayno now, please, for 2 minutes.
Thank you. Good afternoon. My name is Christine Rayno, and I am testifying in support of HB 833 on behalf of Shared Hope International. Thank you, Mr. Chairman, Mr. Vice Chair, and committee members for hearing testimony on House Bill 833. We are especially grateful for Delegate Learman for sponsoring this important legislation. Shared Hope is the only organization tracking, analyzing, and evaluating all 50 states and DC's laws and legislation related to child and youth sex trafficking. We also provide technical assistance to state lawmakers and anti-trafficking stakeholders in a majority of states to increase protective responses for youth survivors. In this capacity, we've been uniquely positioned to ascertain effective practices and policies. Safe harbor, or non-criminalization protection, is a well-established, researched and proven policy for appropriately responding to child sex trafficking victims. The majority of states in the nation have passed legislation to protect child sex trafficking victims from being charged with prostitution. In addition, many states have gone on to increase and expand that protection to include other offenses. The fact that states have expanded their safe harbor laws demonstrates the benefit to all stakeholder groups and the positive outcomes for youth. House Bill 833 remedies a glaring contradiction in the state's criminal code. While children who have experienced exploitation are rightfully identified as victims of sex trafficking under one section of the code, the prostitution law undermines their victim identification by treating the same child as an offender. Furthermore, innovative and smart policies and practices that are designed to protect rather than punish child sex trafficking victims, such as the Regional Navigator Program established in 2019 by the Child Sex Trafficking Screening and Services Act, are undermined when child sex trafficking victims continue to face potential criminalization for their own exploitation. I've also submitted written testimony that includes research demonstrating the efficacy of safe harbor protections for child sex trafficking victims, and respectfully urge a favorable report on House Bill 833.
Thank you very much. Are there questions for this panel? Seeing none, we thank you all very much. I'm sorry, Delegate Howell is raising her hand. Delegate Howell.
Yes, my question is, first of all, thank you, Delegate Learman, for this bill. I have a question of probably the last two people who just testified. When a sex victim gets picked up, a child sex victim gets picked up, I'm pretty sure that they're pretty afraid to say how they got into the situation, and they don't tell on their exploiters. So when they get picked up several times, do you go back and look at all of their charges and take all of those away too?
So this bill would look at a child from the perspective of either when they're first coming into the system or they're already engaged in the system. It does not expunge or vacate the law or the incidents that happened prior to that. So that may be something that we'll have to look at in the future.
Thank you.
Are there further questions? Thank you all very much. We'll go to our next panel. These are unfavorable. We'll hear from Joe Riley, Steve Kroll, Vince McAvoy. Joe Riley, Steve Kroll, Vince McAvoy. Well,
thank you.
We'll start with Mr. McAvoy for 2 minutes, then we'll go to Joe Riley and Steve Kroll. 2 minutes to Mr. McAvoy.
All right, thank you so much, committee. Similar bills to this have been tried in California, and some very outspoken sheriffs and lawmen out there have been highlighting that this is going to expand child prostitution, not reduce it. And so I think that there's a lot of unintended consequences that can come from this bill. Further, when you're lumping in there a host of other crimes that get expunged, and basically, if I'm reading the bill correctly, it's from the aspect of something was committed. Well, do we have someone who's being trafficked? I mean, again, we're incentivizing things, and I do think that this is a slippery slope. This is what California's found, even though they're extremely liberal out there. They haven't gone all the way on this because they see that there are some very sad unintended consequences where you basically will not be able to have the children have inflection points with the law and with help that can get them out of this cycle. This is rape. And I want to give an example that I knew had seen on a case where we had a 35-year-old mother who was worried about her 15-year-old daughter who was having sexual relations with a late 20-something drug dealer. And the weird thing was she took this to our office and she got prosecuted for chastising the child. And so what you see sometimes is that the children want this lifestyle, and then they're going to use these types of laws to sort of get out of those clinch points, which would otherwise have them end this type of activity. I also think, just from a common man on the street issue, that we don't want police having to look at prostitution and try and tally up in their head, like, what age is that person? Should I be pulling them over or not? I think that it's a very scary, slippery slope, and I think it will leave us to not being able to end child prostitution.
Mr. McAvoy.
Thank you for your time, committee.
Thank you. Joe Riley for 2 minutes, please.
Thank you, Chair Clippinger, Vice Chair Moon, distinguished members of the Judiciary Committee. My name is Joe Riley. I'm the elected State's Attorney for Caroline County and the Legislative Chair for the Maryland States Attorneys Association. We are seeking an unfavorable report on House Bill 0833 in its current form. I would like to acknowledge, however, the survivors who have testified before us and recognize their courage. And I will remind this committee that I was the state's attorney who helped move the Maryland States Attorneys Association from opposed to supporting vacatur back when it was done 3 years ago. So we're opposed to this bill specifically because several technical reasons, not in concept. I would encourage you to look at page 4 of the bill, line 11, that's section B. So if you have a scenario where a juvenile has committed an unauthorized use of a motor vehicle, let's say, because that's one of the charges that we're talking about, and the law enforcement officer stops that person and has no indicia that the child is being trafficked. There's no indicia showed that the child does not present that. And then so the child is sent to DJS. There is an initial appearance, and they are at that time paired up with 99.9% of the time a public defender. They give their counsel notice, I'm being human trafficked. I did this because I was human trafficked. At that point, under what this law would be, The state, now, we don't get services immediately. The state has a burden to show by a probable cause standard. I can only assume that's a preliminary hearing in front of the judge or the magistrate to show that that there's probable cause for the charge to exist. That's not what should happen. We should engage this child in services immediately with the regional navigator, have the regional navigator, all parties of reports, the state, defense, the court, DJS, and then we can make a determination on how to proceed at that point. Just having a period at the end of evaluation of the child's status as a victim of sex trafficking, period, not have 1 and 2, because if you look at 2, it says there's a reason to believe that the child is committed the act as a direct result. A reason could be anything. How about the child has said that they are a victim of sex trafficking? That sounds like a reason. There needs to be a higher standard than just a reason. So there's some technical things on this bill that need to be worked on. I'm confident with our prior work with the advocates for this bill that we can get there. It's just not ready at this point. We seek an unfavorable.
Thank you, Stephen Kroll.
Mr. Chairman, members of the committee, I'm Stephen Kroll, the Executive Director of the Maryland State's Attorneys Association and the State's Attorney Coordinator. I've been prosecuting cases since 1984. Last Monday, proponents of this bill came to talk to us at the Maryland State's Attorneys Association legislative meeting. We gave them ideas, good ideas, because they've incorporated several amendments. So like Mr. Riley said, we agree with the concept. And we think that if the advocates take our recommendations and make certain amendments, some of them they've already done, but we want to see those amendments, then we could get together with those advocates and get a good bill together. As Mr. Riley said, these are just technical problems, but I am confident that between Ms. Jordan, Ms. Emerson, and Ms. Rodriguez, we could come together and have a good bill. I really am that confident. But the proposals we gave them, they hadn't thought about beforehand. And they said they were good ideas and they were going to make those amendments. So in short, I want to look at those amendments, make sure they're what we wanted, and in turn, hope to come back with these advocates to propose a good bill. So we're opposed at this point, but that's just the way it's written now. But we look forward to further conversation with those amendments. Thank you.
Are there questions for this panel? All right, thank you all very much. That's going to conclude the testimony on House Bill 833. We appreciate everybody's testimony today, and we're going to go to the last bill for or during our bill hearings, at least today, and that is Delegate Lopez's bill, House Bill 754. We'll hear from Delegate Lopez for 3 minutes, then Patrice Smith, James Dold, Nina DeJong, Sarah Cruzan, Jarrett Harper, and Michael Mendoza. We'll hear from all of them. Let me just double check. And then we might have another panel after that. So we'll hear from all of them in the first panel, then we'll take questions. Delegate Lopez, if you'd like, for 3 minutes.
Thank you, Mr. Chair, Vice Chair Moon, and judiciary colleagues. For the record, I'm Delegate Leslie Lopez, here to ask for your support for HB 754, which ensures that Maryland uses trauma-informed and age-appropriate approaches when sentencing minors. Under this bill, if the court determines that a minor was a victim of a sex crime or human trafficking up to a year before the date they committed a crime, the court may transfer them to juvenile court for sentencing. We know from our work in this committee that children's brains develop differently than adults, and that exposure to adverse childhood experiences are traumas that can further change the way the brain functions. Nonetheless, children who are victims of sexual abuse who retaliate directly against their abuser have been convicted in adult court and given life sentences for trying to get themselves out of abusive situations. Many of you are familiar with the case of sex trafficking victim Centoya Brown, who was a minor when she killed a man over twice her age who picked her up for sex and then was subsequently sentenced to life in prison. In California, Sarah Cruzan, who you'll hear from today, was sentenced to life in prison for killing the man who had started trafficking her when she was just 12 years old. While both of these women were eventually released, they never should have had to endure the adult criminal justice system in the first place, and neither should any child victim of sexual abuse in the state of Maryland. While these victims can claim self-defense in court, Maryland's self-defense precedent does not allow for the unique circumstances that children go through. Children trapped in abusive situations may not have had the luxury of waiting for conditions that provide for self-defense when they attempt to free themselves. For example, they may plan their actions or wait for their abuser to be asleep or otherwise be less dangerous before taking action. And so, in conclusion, minors who are the victims of sexual abuse and human trafficking are some of Maryland's most vulnerable citizens. Rather than using the criminal justice system to punish them when they retaliate against their abusers, Maryland should work to provide them rehabilitative services so that they never are subject to that abuse again. Thank you, and I ask for a favorable report.
Thank you. Let's hear from Patrice Smith, please, for 2 minutes.
Hello, my name is Patrice Smith and I am a survivor. At the age of 16, I was incarcerated for actions committed against my abuser who began sexually abusing me at the age of 15. Upon indictment, I was immediately referred to Supreme County Court to face criminal charges as an adult. I myself had no prior involvement with the justice system and was immediately overwhelmed with trying to understand the process and procedures. I admitted to the court everything I had endured up until that point, and it was not recognized. My case was viciously prosecuted in the media, where I endured ridicule from the county correctional officers as well as other incarcerated individuals. I woke up to public opinion and scrutiny, judgment about the sexual abuse I had endured. The shame I had been holding in increased 1,000 times over. After having been incarcerated for a year, I was found guilty by a jury. This jury was made up of adults who were closer in age to my victim than myself. So how could they understand the thought process of a 15 or 16-year-old when they themselves were so far removed from those golden years? They questioned why I did not tell anyone, but who could I have told? I was ashamed, I was scared, and when you are a child, the loneliness of your pain silences you. I was sentenced to prison for more years than I had been alive. I was given a 25 to life sentence. The court failed to consider the abuse I endured. It failed to establish that as a child, I had the right to be free from that abuse, that I had a right to protect myself. It failed in its duties to conduct a thorough investigation into my life, to consider factors such as violence, peer pressure, mental capacity for making sound choices. I was thrown away. I was made to feel that my life was not valuable, that I somehow should have kept enduring the sexual abuse. I was sent to an adult prison where I struggled with these identities of being a victim and a perpetrator of a crime. I learned to make an abnormal environment normal. I struggled for years to understand why fighting for my life was wrong. Why did I not deserve to be free? Why did what happened to me not matter to anyone? Why was I not considered a victim? All I wanted was for him to stop touching me, stop threatening me, to be able to look at my father and not feel stained, dirty, and unworthy. I'm pleading with you to pass this bill. The protection of our youth has to be a priority. The courts can no longer turn away, because if the world fails them, they should have you to be their defenders, to be their protectors. You alone are tasked with making sure every factor that could have influenced their judgment is considered. You alone are tasked with giving them all the protection that they have lost. It is your duty. This shouldn't be a choice. There should be no fear in wanting to protect our children. In 2020, after having served 21 years and 9 months, I was released in New York under a new law called the Domestic Violence Survivors Justice Act. It was finally acknowledged by the court, all of the abuse I had endured. 21 years, ladies and gentlemen, 21 years. Please do not allow another child to be savagely thrown away and made to feel as if their own life doesn't matter before they even had a chance to live. Thank you.
Ms. Smith. James Dold for 2 minutes, please.
Thank you so much, Mr. Chairman. James Dole for Human Rights for Kids. Want to thank Delegate Lopez for her leadership in introducing this bill. A lot of you know me as CEO and founder of Human Rights for Kids, but I'm also, before I was the founder and CEO, I was a survivor myself. I was a survivor of child labor trafficking and sexual abuse, which is why these issues are so important to us as an organization and why we fight so hard on behalf of child victims. There's two critical components to House Bill 754. The first is the requirement that when children are sentenced in adult court, that their child status actually matters, that judges consider age, trauma history, family background before they impose whatever sentence they're going to impose. So it doesn't restrict the judge in terms of what sentence they can impose. It just says children are different. We need to make sure that we treat them differently in the criminal legal system when they've been convicted in adult court. What we know too from the data, as I've mentioned in my prior testimony on other bills, we see that 48% of children experience roughly 4 or more adverse childhood experiences. That is particularly acute for girls, where 73% of them have been both physically and sexually abused. And the second component of this bill, which is also really important, is the requirement to make sure that when we have child sex crime victims or child trafficking victims who commit offenses against the people who have abused them, and the judge finds that by clear and convincing evidence, that we give judges more discretion in those cases. Ask yourself this one important question, that if Patrice Smith or Sarah Cruzan or Jared Harper, who you're going to hear from later today, was your child who had been sexually abused, raped, or trafficked, what would you want done? Wouldn't you want judges in those cases to have as much discretion as possible to potentially send that case back down to juvenile court? Under Maryland's current statute, children charged with first-degree murder cannot be sent down to juvenile court. They have to be sentenced as an adult. And so this exception, making this exception that allows for judges to have that discretion for child sex crime victims is absolutely essential. And then just one quick word about the amendments. There are 2 amendments with this bill. What they specifically do is they strike the blended sentencing section in subsection C3, which was a concern raised by both the Public Defender's Office and the Maryland Judicial Conference. So it addresses those concerns on that front. And the second, it clarifies subsection C so that it makes clear that that section applies only specifically to child sex crime or human trafficking victims whose offenses were committed against their abusers. And for with that, Mr. Chairman, we would urge this committee's favorable report. Thank you.
Nina DeJong, please.
Good afternoon. Thank you to the chair and members of this committee for having me. My name is Nina DeJong, and I'm the policy director at ECPAT USA, an organization dedicated to ending the commercial sexual exploitation of children. I also serve on the legislative committee for PG County's Human Trafficking Task Force in Maryland. I come before you today in strong support of HB 754. Too often, children are unfairly prosecuted, sentenced, and incarcerated within the adult criminal justice system. This bill stands to significantly impact outcomes for children who are currently facing the criminal system. It allows judges to consider adverse childhood experiences and trauma. Additionally, the bill would allow judges to send cases of children who are victims of trafficking back to juvenile courts for disposition. This is essential because the criminalization of child sex trafficking victims continues to be an issue. Far too often, the judicial system penalizes minors who are being exploited, and these children become part of the system without any consideration given to the awful abuse they endured as a result of their exploitation. Traffickers leave their victims hopeless and engulfed in fear. Escaping this vicious reality seems merely impossible for some. Allowing courts the ability to exercise leniency in these cases is vital. Our legal system's inability to view children as victims in these circumstances effectively prevents it from being able to adequately serve vulnerable youth. To be clear, children should not be charged for crimes that occurred as a result of their victimization. I say this with sadness, but if the judicial system is going to continue to criminalize children, then it must be done from a lens and an approach that understands the complexity and trauma and the needs of children who come into the courtroom, which can be done through juvenile court proceedings. Treating children in a trauma-informed and age-appropriate manner is critical to both their psychological and physiological well-being. It is incumbent upon us to do all that we can to ensure children are able to reintegrate into society with the necessary resources and legal support. To conclude, ECPAT USA has a Survivors Council who tells us time and time again that trauma-informed services are essential to helping protect young people who remain at risk. Thank you again for your time.
Thank you very much. Sarah Cruzan, please. Sarah Cruzan. Ms.
Okay.
Cruzan, are you operating a
yes.
vehicle or are you pulled over?
No,
on the side
sir.
of the road? Okay.
I am pulled over for sure. Yes, absolutely.
2 minutes.
So, okay. Well, thank you. I've been prepared.
Good. Go ahead.
Okay. So, yeah, my name is Sarah Jessamy Cruzan, and the majority of my life I was identified as Cruzan W59700 while haunted by horrendous, embarrassing, unspeakable situations I was subjected to by the adults in my life and the community members as well. To this day, I'm in therapy doing my best to make sense of the why behind all of the abuse. Being an invisible voice as an unidentified victim of child sex trafficking for so many years, I found that HB 754 would allow judges the discretion to make decisions based on trauma-informed best practices to enhance the overall wellness of our children who come in contact with our justice system. The vast majority of our children in the justice system are contending with early childhood trauma and unmitigating adverse childhood experiences. I was one of those children. About 90% of the children in the justice system have experienced at least 2 of the 3 adverse childhood experiences, which may include anything from abuses of neglect to having an incarcerated parent or living with a family member who's abused substances. I've experienced 10 out of the 10 adverse childhood experiences. Despite being a victim of child sex trafficking, sex abuse, and rape committed by the man that I did kill, I was tried as an adult where none of the abuse and the complex trauma I experienced through my childhood was admitted into evidence. I had no victim's advocate. I had no therapeutic modalities dealing with the trauma. There was no trauma-informed care to offer to me. As a rape victim, I was my only witness. And after 2.5 days of trial, I was ordered to pay a $10,000 victim's restitution and serve a life without parole sentence, plus 4 years. The prosecution, the judge, and the media depicted me as a sophisticated monster, the worst of the worst, and sentenced me as such. The justice system sentenced me to life imprisonment without parole, plus 4 years for killing the man who victimized me for nearly a third of my young life. I was paroled October 31st, 2013. I think because of the fact that we're limited to just 2 minutes and being silenced and feeling invisible, I really feel that, like Nelson Mandela once said, there is no keener revelation of a society soul than the way in which it treats its children. What does it say about our soul then if we allow our children who have been trafficked to be sentenced to decades in prison for having committed crime against their abuser? Children like us deserve to be protected by the system, not traumatized by it, and not to develop a relationship within it that is abusive and more trauma-inducing situations. The legislation before you offers an opportunity to create a system that centers care and not cages for our most vulnerable children. And I ask you in this situation to please meet these children with empathy, compassion, understanding, and love. Thank you.
Thank you. Jarrett Harper, please.
How you guys doing? I would like to express my gratitude for the effort and work it takes each one of you to examine the laws and the recommended needed reforms. My name is Jared Harper. I'm a passionate advocate for criminal justice reform, working for positive change in the foster care system, as well as ending life sentences for children while creating better rehabilitative resources for citizens returning to society. Your time is valuable, and I am encouraged by this invitation to share my personal experience within multiple systems, mainly the California sentencing laws, and express the serious need for reform when it comes to life without the possibility of parole. On June 18, 2019, I was released from prison after serving 20 years in Lancaster State Prison, just right outside of Los Angeles. At the age of 16, myself and a co-defendant and I took the life of a man, and I was convicted of murder. I was sentenced to life without the possibility of parole, plus 10 years. I faced a murder trial without the support of anyone but the court-assigned public defender. Caught in the foster care system since infancy, my choice has never felt like my own. So much as like really functioning, like I was really like just functioning, trying to survive. From the age of 6 to 13, I was sexually abused by my neighbor. I had grown to trust him. In an effort to protect myself and my younger brother, I took the life of my abuser. I've learned when we encounter troubling circumstances, we are faced with two options: fall a victim or rise above them. In my case, the latter was made possible by the former. In the years of serving my punishment, I actually developed insight into myself. And in that process, I also developed insight into the harm of other people. And I started to help those people while in prison. And it provided me with just so much insight into myself and into the harm that had took place. And after 20 years of doing self-reflective work and doing self-help programs, on August 17th, 2018, I was released with the support of advocates such as Brian Stevenson, John Legend, Elizabeth Calvin, and so many other countless advocates. My sentence was commuted by Governor Jerry Brown, and I was later released by Governor Newsom out here in California. As I sit before you guys today, sharing my first 39 years of life with you all, it is my mission to continue the work for change within each system that disproportionately traumatized me while influencing those still impacted by harsh sentences to rehabilitate and transform, to be considered safe and whole to come back out into society. I support this bill.
Mr. Harper, I'm sorry, I'm going to need to ask you to begin to wrap up, please.
I support this bill because I know what it's like to not have my trauma looked upon. I know what it's like to be sent to an adult court system without ever being considered. And I just think that it's important that you guys reevaluate the people who are in your prison systems and really look at the trauma that they endured before they committed their crimes. Thank you for listening.
Thank you very much. We'll hear now from Michael Mendoza, please, for 2 minutes.
Dear Chairman and honorable members of the committee, my name is Michael Mendoza, and I'm the Director of Advocacy with the Anti-Recidivism Coalition, and I thank you for this opportunity to speak in support of this bill. This bill is very important to me because while in the 10th grade, at the age of 15, I made the worst decision of my life and participated by sitting in the backseat of a car during a gang-related murder that unfortunately took the life of another young man. I was immediately arrested and held accountable as I should have been. I had never been arrested before or in trouble with the law. However, I had never felt so hopeless. Standing before a judge being tried as an adult, convicted to life in prison, felt as if the whole world had given up on me and I would never go home. Young people in prison, in adult prisons, face sexual, physical, emotional, and mental abuse. Most never make it home. I was more worried about my safety rather than my rehabilitation. But by the grace of God, policy saved my life and allowed me to prove I was no longer that 15-year-old kid anymore. This bill considers the trauma and victimization that happens in a child's life prior to their system involvement, and that children are developmentally different from adults. More importantly, this bill will save lives and make families healthy and whole. For these reasons, the Anti-Recidivism Coalition supports HB 754, and I respectfully urge this committee to issue a favorable report. Thank you.
All right. Other questions for this panel? All right, seeing none, we thank you all very much for your testimony today. And we're going to move to the next panel. We're going to go to Mikhail Gross, Kimberly Watts, Nicole Hanson-Mundell, please, for 2 minutes each. Ms. Gross.
Yes. Can you
Go ahead for 2 minutes.
Thank you. My name is Michal Gross, and I'm an assistant public defender in Southern Maryland, where I represent youth in both juvenile and adult court. I am signed up as favorable with amendments, but the sponsor has already submitted those amendments, as Mr. Dole discussed earlier, and so I'm now testifying in support of HB 754. The brain science tells us that children are different than adults, and trauma only exacerbates those differences. We know that most kids involved in the justice system have been exposed to adverse childhood experiences. Those experiences cause them to react differently to situations that might not seem like a threat to an average kid, let alone an average adult. But the criminal justice system in Maryland treats these children as adults, ignoring the trauma and the experiences that they've been through. Self-defense that was discussed earlier requires a finding that their actions were reasonable, not taking into consideration everything that they've been through beforehand, all of the trauma that they have experienced. And what the criminal justice system does is it doesn't allow them a chance to be treated like the children that they are and get the treatment and care that they deserve. So when you have a 16 or 17-year-old who has already been trafficked, been beaten, been broken by an abusive adult who finally reacts and strikes back against the person who has struck them repeatedly, that 16 or 17-year-old is then incarcerated with adults, charged as if they were an adult, punished as if they were an adult, without consideration for what they've been through. without even the option of transferring their case to juvenile court, even for children as young as 16 years old. If these children only got the help that they're asking for, they could be rehabilitated. The underlying trauma could be addressed and they'd have a chance for a life ahead, instead of the continued sexual abuse, rape, and the suicide-inducing conditions of an adult prison. And my written testimony goes into the statistics behind all that. When we see a 16 or 17-year-old crying for help, we shouldn't discard them, and instead we should offer them assistance. And so for these reasons, we urge the committee to issue a favorable report, and I'm happy to answer any questions about the logistics of this and how it would work within the juvenile and criminal court system.
Kimberly Watts, please, for 2 minutes.
Thank you. I'm Kimber Watts. I'm an attorney with the Office of the Public Defender. We ask that you issue a favorable report on this bill as amended. The hallmark of all children, including adolescents, is that their brains are still growing and changing. Those changes continue into early adulthood. Having been teenagers once, most of us will remember it was a time of heightened sensation-seeking and risk-taking behavior, when the opinions of our peers had overblown importance. Over the last 25 years, we've gained a better understanding of the biological basis for these behaviors, but very quickly, the prefrontal cortex and the limbic systems are at odds in adolescence. The prefrontal cortex enables us to intentionally control our emotional responses and impulses, and enables us to accurately assess the risks involved in our behavior. And during adolescence, it's weak and underdeveloped. Unfortunately, for kids everywhere, the limbic systems associated with impulsivity and emotion are hyperactive. For example, the amygdala, which reacts to perceived danger, is highly active in kids and overproducing cortisol and adrenaline, resulting in disproportionate fight or flight responses. In other words, at the same time as the part of our brains that tell us how to best handle situations is not functioning all that well, the part that tells us that we are in extreme danger is running on overdrive. To illustrate how this plays out in the real world, I'll use an example of my client, Andrew Zaragoza. This committee previously heard some of his testimony, but to briefly summarize, when Andrew stood up to his sexually abusive mother and told her he was calling Child Protective Services, she stabbed him and he killed her. The state's attorney argued that he went beyond what was necessary for self-defense, and he was convicted of second-degree murder at the age of 16. As an adolescent, his amygdala would have been overproducing the cortisol and adrenaline that cause the physical sensations that tell us when we're in danger, while his underdeveloped prefrontal cortex would have had difficulty accurately assessing when the danger was over. So as a 16-year-old, and in that moment of panic, Andrew couldn't see the way an older person might have. When it was safe to run. And so for these reasons, we ask that you pass this bill or urge a favorable report. Please feel free to contact me with any questions.
Thank you very much. Are there questions for this panel? Ms. Hanson-Mundell is not in the waiting room. Seeing none, we thank you all very much for your testimony. Now we'll go to those people in opposition. Ryan Massey, Joe Riley, Steve Kroll, Vince McAvoy. All right, we're going to start with Joe Riley. Mr. Riley, for 2 minutes, please.
Thank you, Chair Clippinger, Vice Chair Moon, distinguished members of the committee. My name is Joe Riley. I'm the elected state's attorney for Caroline County and the legislative chairman for the Legislative Committee for the Maryland States Attorneys Association. We seek an unfavorable report on 754. We are very sympathetic to the stories that you've heard, tremendously compelling narratives. But I do want to debunk one of the things that was said, in that it was indicated that a juvenile doesn't have an opportunity to transfer their matter back to juvenile court. They do. It's called a waiver hearing or a reverse waiver hearing if the case starts in adult court. And those are appealable if the decision doesn't go in the juvenile's favor. So all of these factors that are described in the bill are already done at the waiver hearing or the reverse waiver hearing. I would also like to point out that the exceptions for sex crimes, it talks about a clear and convincing evidentiary hearing. I'm assuming that would be done by the defense, but not really sure how that hearing would take place. Also, there isn't a direct result component either. When we talked about the previous bill, the safe harbor bill, there was a direct result portion of that bill, if you recall, that the sex trafficking crime had the underlying conviction had to be a direct result. That's not here. So you could commit an armed carjacking of a female Marylander, let's say. And then at your hearing, on you're being sentenced, you then show that you were a victim of sex trafficking. Awful thing that happened, but you were a victim of sex trafficking 9 months prior in an unrelated case, and the case should go back to juvenile court. That's not really how it makes sense. So we seek an unfavorable report on House Bill 754. Thank you.
Thank you very much. Steve Kroll, please.
Mr. Chairman, members of the committee, good afternoon. I'm Stephen Kroll, the State's Attorney Coordinator for Maryland, Executive Director of the Maryland State's Attorneys Association. And again, I've been prosecuting cases since 1984 here in opposition to House Bill 833. First thing I'd like to say is I understand there have been amendments that have been filed in this bill, so I can't really comment on the bill until I see the amendments, and no one has forwarded me the amendments prior to this time. Second, as we speak, across the street in the Senate, conversations are going on a similar bill. So in order not to inflame things, because some people say I tend to inflame things sometime, I'm not going to say anything else and let those conversations proceed at this time. And I think they're going to be fruitful. I hope they're fruitful. So for those reasons, I will say we are opposed to House Bill 833 and ask any of the sponsors, any of the bills, please forward them to me before testimony begins. Thank you.
Ryan Massey. For 2 minutes.
Good afternoon, Chair. We are on 754, correct?
Yes.
Okay. Good afternoon, committee. My name is Ryan Massey. I'm a member of FOP Lodge 4, which represents the police officers in Baltimore County. I'm a 23-year vet. I spent 14 years in the homicide unit. Since the start of the legislative session, January 12th, 6 juveniles have been shot in Baltimore City and 2 in Baltimore County. During the past several months, Mayor Brandon Scott and Commissioner Harrison have publicly stated that many of the problems with the increase in shootings are due to conflict resolution problems. I have a question. Were the aforementioned juveniles all engaged in conflicts with solely adults? I would say the answer to that is no. If you look at the DJS website, DJS statistics state that once a juvenile is found guilty, the average sentencing is 238 days. I want to highlight 2 cases that were handled here in Baltimore County: the murder of a police officer named Amy Caprio and the murder of a gentleman named Carl Lackle. They were both killed by 15-year-old juveniles charged as adults. Officer Caprio was killed in the line of duty, keeping the citizens of Baltimore County safe. And Mr. Lackle was a witness to a murder in Baltimore City. He gave the city police information that led to the probable cause, which led to the arrest of the killer. Every day, we ask citizens and police officers to do what both Officer Caprio and Carl Lackle did when they were murdered, to take action to keep Maryland safe. The Supreme Court has reviewed sentencing for juveniles charged as adults in hundreds of cases, and the only sentence determined to be unconstitutional is life without the possibility of parole, not lengthy sentences for committing heinous crimes. The juvenile court only has jurisdiction until the juvenile turns 21. There would be no mechanism to place the juvenile on parole or probation once they reach age 21 and are released from custody. Lastly, Governor Hogan has put forth legislation to try to keep the most violent offenders in jail. Why would the Maryland General Assembly also pass legislation to keep the most violent offenders out of jail simply because they are juveniles, even though they were charged as adults? With the rise in violent crime around the country, now is not the time to incentivize juveniles committing the most serious crimes. Under this legislation, the murderers of Officer Caprio and Carl Lackle could receive only a 6-year maximum. This is why I asked for an unfavorable report on this bill. Thank you.
Thank you very much. Vince McAvoy, please, for 2 minutes.
Thank you so much, committee. In 6-235, it says, notwithstanding any other provisional law when sentencing a minor convicted as an adult, the court may impose a sentence less than the minimum. Also point to what the judge is considering for factors for waiving up and down: your age, mental, physical condition, range of treatment, nature of crime, public safety, the public. The bill is duplicative in nature, and it's, as was just spoken, the absolute worst thing to happen right now. As we discussed last week, in 99% of the time, we do not charge kids as adults. When do we? Kidnapping, carjacking, murder, rape. That's why they're charged as adults, because they chose a big boy crime and they're going to get that sentence, or they should. The largest growing group of criminals in America is our youth. As I've told you for years, the difficulties when they don't have fathers. The committee's chosen to do nothing to shore up family bonds with fathers. So you create children raising children. And in Baltimore City, I see police refusing to arrest children until it gets into a life-impacting situation. So I ask you to do something to look at this through societal expectations. If you have these select group of kids, again, less than 1,000 in 10 years, you have the core issue of can control them. Carjack, raped, etc. I urge you to vote this down. Again, you all are going to be voting on drugs in about a half hour. Think about the mental state that you're giving these children when they're ingesting drugs. They're not thinking rightly, and making more drugs available, making them exposed to it, is not going to help their long-term growth.
Thank you very much.
Maturation. Thank you so much, committee. Have a good night.
Delegate Lopez, then Delegate McComas. Delegate Lopez.
Sure. Thank you, Mr. Chair. My question is for Mr. Riley. I understand the point you're trying to make, but the reverse waiver hearing does not apply to children who are charged with first-degree murder.
Right.
Yeah, so I just wanted to get your response to that.
In regards to first degree murder, you are correct. If they're charged with first degree murder, the reverse waiver doesn't happen. However, if this hearing somehow a first degree murder conviction, not what Centoya Brown was convicted of, I don't think she was convicted of first degree. Then you want to send a first degree convicted murderer back to juvenile court for sentencing when the most that can happen is 6 years. I'm going to have to talk to victims about that, and I just don't see how that's fair to the victim's representative, what you're talking about here.
Delegate McComas.
Mr. Chair, this is a question for, well, the gentleman, I believe it's Mr. Massey from the FOP, but also if Mr. Kroll or Riley want to speak on this. My concern is you know, we have a proliferation of gang violence, I suspect, and a lot of times the gangs or the drug lords are going to employ minors to do the dirty work because they know that they're juveniles and they're not going to, you know, get slammed. So I see this as kind of like an incentive to employ more juveniles to do bad things because, you know, 6 years, if you say, well, the max you could get is 6 years to a kid, that they're just not gonna, it's not gonna really compute, you know, that's a really short period of time or even a long period of time. I mean, it's an incentive to use them. And so I would like to get your thoughts, you gentlemen. So please, am I off base or right?
No, ma'am, Delegate. And actually, in the case of Mr. Lackle, and I didn't mention that I provided written testimony also that highlights other cases. But in the case of Mr. Lackle, it was a 15-year-old and he was actually joining the Bloods gang and they recruited him. He had specific instructions not to kill him in Baltimore County. he was told to kidnap Mr. Lackle and kill him in the city. And we charged a total of 5 or 6 people with that murder. But they specifically targeted, the gentleman's name is Jonathan Cornish, and it was handled in federal court. They targeted him because he was a juvenile. And there would be no incentive for juveniles not to commit more crimes, because the max they could get is 4 or 5 years. And again, according to DJS, the average placement is 238 days.
To answer your question, Delegate McComas, on House Bill 754, so I got that straight. Yes, it's possible.
I would also like to add, Delegate McComas, you're giving too much credit to the people who are bringing in these juveniles. They don't give them proper legal advice. So they're probably telling these juveniles that they're not going to get in any trouble at all. Not just that they're going to be doing it for 6 years and the juvenile makes that decision.
Any further questions for the panel? Delegate Bartlett?
Mr. Riley, but wouldn't that be even more reason to pass House Bill 754 so that that individuals who are minors who don't know what they're doing or know the consequences of what they're doing?
And in 95% of the cases that a juvenile is involved, much more than 95%, they're going to be in juvenile court. The cases that they're going to start in adult court, they're going to have a waiver hearing. The only time that they're not going to have a reverse waiver hearing is on first-degree murder. So no, I don't think in cases of first-degree murder, when you have only a victim's representative to talk to, and you have the most serious offense that can be committed, that we need to have this sort of hearing. And they do have this very similar type of hearing in a reverse waiver hearing, and it just becomes duplicative and draws out the time. And victims at some point need to be given closure by this committee, and we ask for an unfavorable report on the bill.
Are there further questions?
I have one more.
Sorry, go ahead. Delegate Bartlett, keep going. Go ahead.
Okay, thank you. So, I understand what you're saying about the victims. By all means, I understand that, and I have due respect for victims. But in some of these cases, the children are victims too. So it's a balancing act, unfortunately for us. So my next question is, I wanted to ask you about, are there any of these factors that are listed that you think should be something that a court should consider? Because there's several factors that are listed that a court can consider. These are not ands, these are ors. You know, they could consider any of these things. So is there anything in here that you think a court should consider before, so that, you know, they would consider not necessarily sentencing a child or sentencing a child as an adult?
At the moment, a sentence is to be handed down by the bench. The defendant and their counsel always have the moment for allocution. These factors, any factors, all factors that are brought up in allocution should be considered by the court before they enter into a sentence.
And so I guess I don't understand the opposition then.
Well, the opposition is, I disagree with the bill in that it says you should consider them and then send the matter to juvenile court. I think it should be considered, absolutely. But I don't think the result should be sending it to juvenile court.
Okay, so if a judge considered the factors and said, okay, I'm gonna sentence you to 6 years, you would think that is also a possibility, and you would think that
depending on the charge, I assume that the bench has made I never complain about sentences, so you'd have to ask somebody else. If the judge has considered all the factors, the state's presentation, and decides that a 6-year sentence for whatever we're talking about, I don't know what crime we're talking about, is the just sentence, then we'll deal with that.
Thank you, Mr. Chair.
Delegate Grammer.
Thank you, Mr. Chair. A question for the gentleman from the FOP. So I met with some of the members of the FOP recently in Baltimore County, and they talked about some of the gang activity that's grown on the east side of the city and it's extended to the county. They mentioned juvenile participation and how these juvenile-related laws and systems can be exploited to really minimize any kind of accountability there would be. They mentioned like the Out of the Mud gang and how like the gentleman who was shot recently, shot in the head in a carjacking in the city. You know, a lot of these cases tend to be juveniles who are soliciting young people specifically because they know the penalties are going to be minimized. So I know you mentioned it briefly, but can you speak a little bit more broadly how that's happening right now? And if passed, would this bill diminish that, or would it enhance their ability to get around the system with these laws?
This bill is passed, and I'll use an incident from 2 weeks ago. I listed some, I think I listed this in my written testimony, but we had a shooting at Catonsville High School 2 weeks ago. Everybody involved in a juvenile. So if this law went into effect, essentially you have, you know, that's a problem we have now is school shootings. So you would be effectively gutting the criminal justice system, and we would probably have more school shootings. Even that, you know, kids go to school. This was an incident at a school where kids had problems with one another. Somebody pulled out a gun and shot somebody, and the victim was a juvenile. 2 or 3 of the suspects that were charged were juveniles. So yes, this law would exacerbate juveniles knowing that there are no consequences for the most serious crimes. And that's just the regular juveniles. That's not the organized ones that you're talking about in gang activity. And, you know, this is just over the other side of the bridge in Catonsville, but they really don't know the boundaries. So that can go to the east side of Baltimore County. It's going to go to the west side of Baltimore County, go to northern Baltimore County. So it will exacerbate, and the juveniles will, they know the law. They know what they can get away with, and it will make things worse. And at a time where violence is rising, and we had a record number of homicides last year in Baltimore County.
Can you speak briefly how this would relate to the gang activity, if you believe that to be the case?
I believe it would be the case because, again, in Mr. Lacko was killed in 2007. Things have gotten worse, and that was the Bloods gang. They were recruiting Mr. Cornish to join the Bloods gang, and he was joining that gang, and this was his initiation into that gang. Again, we charged 6 other people, and all the others were adults. So I know the delegate mentioned about the kid being the victim, but at 15 years old, they knew that murder was wrong. He asked Mr. Lacko if he knew the way to heaven right before he shot him. I'm not sure you can classify Mr. Cornish as a victim. He's trying to get into a gang, and that would make the problem significantly worse if this legislation is passed.
All right, thank you.
Delegate Lopez.
Thank you, Mr. Chair. I have a question for Mr. Massey. Do you have any data about how many of these gang members, as they've been called, have been victims of sex trafficking or childhood sexual abuse in the past year? Because that's what the bill pertains to.
I do not. And when I read the bill, I saw the cutout for sexual human trafficking and sex abuse, but I don't know how many of the people that I've dealt with the gangs have been sexually abused.
Gotcha. Thank you.
Further questions? Seeing none, we thank you all very much. And that concludes the testimony for House Bill 754. It concludes the testimony for legislation today. Members of the committee, we will come back for a voting session at 6:30 p.m. To give people who are in Annapolis the opportunity, if they so desire, to take the voting session from home. So we'll start then. The voting list has been put up and posted and been made available. So we will see everybody back in about an hour and 45 minutes. Thank you all very much. Our next hearings for bills will be next Tuesday, voting session Thursday and Friday this week. So with that,